We'll be calling item number 1. Okay. Item 1.
After some time.
You have a record?
I don't know.
I think we need the we'll need the record.
Immediately after.
Hey, Mr. Hussain? 14th? Reopening?
15.
No, then we'll 16.
Awesome.
I like a second law. Mr. M.K. Hussain, Land Counsel for the petitioner, D.K. Sharma, Traditional Advocate, Senior Advocate, Government Advocate, Assam. For the response number 128, Mr. A. Kolita, Land Counsel, on behalf of A. Parahar, Land and Central Government Counsel for the response number 9 are present. Mr. Sharma has submitted that an affidavit in opposition on behalf of the response number 128. Has been filed yesterday, and the state affidavit is not on record. Post of 3 years has submitted that the relevant records are presently not available with him. Post of, you have received copy? Mr. Hussain has submitted that he has. You want to file any reply? Mr. Hussain, Land Counsel for the petition, submitted that he has received a copy of the affidavit opposition filed on behalf of the state respondents, and he will take instruction as regards filing of affidavit in reply, and if so advised, he will file it within 2 weeks' time. Post of the affidavit in opposition, stated to have been filed on behalf of the state respondents, is to be tagged with a case record. The petitioner shall file the affidavit reply, if any, within 2 weeks' time. The Land State Council shall obtain the relevant records to place before the court and shall obtain the relevant records ready on the next set of listing, list the case on 16. Item number 2. Conviction under
section 376(3) of the IPC, read with section 3 POCSO.
Mr. K.P. Pathak, Legal Aid Counsel.
Legal Aid Counsel.
Learned Counsel for the accused appellant, and Ms. S.H. Bora, Learned Traditional Public Prosecutor for the response number 1 from our state of Assam. So this criminal appeal under section 4152 for a narcotic Honita 2023 is declared against a judgment and order. An order dated 24/7/2024 passed by the Court of Learned Additional Sessions Judge Special Judge within POCSO Morrigaon in POCSO case number 11 of 2021, arising out of Morrigaon Police Station case number 458 of 2019. Posted by the judgment and order dated so and so, the accused appellant has been convicted for the offense under section 376 within bracket 3, Indian Penal Code, and section 6, Prevention of so and so Act. Post of in view of section 42 of the POCSO Act, the accused appellant has been sentenced to undergo 376 3 450 IPC and section 6, and we have section 42 of the POCSO Act, accused appellant has been sentenced to undergo. Under which section?
He was convicted under section 376(3) since that reflected the highest punishment. He was sentenced under 376(3).
Sentenced to undergo rigorous imprisonment for a period of 20 years and to pay a fine of rupees 10,000, in default of payment of fine, to undergo further rigorous imprisonment for 3 months under section 376 within bracket 3 IPC. So for the offense under section 450, the accused appellant has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 5,000, with default stipulation. The sentences are ordered to run concurrently. First off, we have gone through the contents of the memorandum of criminal appeal. First off, the criminal appeal is admitted for hearing. The case records of so-and-so case number we call for issue notice returnable in 4 weeks as MS Bora has appeared and accepted notice on behalf of the respondent number 1, State of Assam. Issuing the formal notice to the state, the state respondent is dispensed with extra copy of memo within 3 working days. The appellant shall take steps for service of notice. I'm the respondent number 2 informant in terms of the practice direction. So the learned traditional public prosecutor is to obtain a report as regards service of notice. I'm the respondent number 2 from the officer in charge, Moringham Police Station, before the next listing. I
will not press it now, Your Lordship, after me.
I don't know what tree.
heard Ms. S.H. Borders and its additional public prosecutor for the respondent number 1 state. Post up. The learned legal aid counsel is found absent today on call. Case criminal appeal under section 4152 of the Bharatiya Nagaric Surakha Samhita 2023 is directed against a judgment, an order dated 5/2/2025 passed by the Court of Learned Session Judge Kamrup, at Taminggaon, in Sessions case number 19 of 2021. By the judgment and order dated 5/2/2025, the accused appellant has been convicted for the offense under section 302, Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000, in default of payment of fine, to undergo rigorous imprisonment for another 6 months. Full stop. Okay. I've gone through the contents of the memorandum of criminal appeal. The criminal appeal is admitted for hearing. The case records of Sessions case number 19 of 2021 we call for issue notice returnable in 4 weeks as so appeared accepting notice on behalf of the respondent state. Party 1 actually. These are case number 4 weeks. The name of Mr. U. Chaudhary, and legal aid counsel for the appellant, is to be reflected in the appellant side in a call list.
May please your worship. The conviction is under section 6 of the POCSO Act and section 9 of the Prohibition of Child Marriage Act. My lord, the sentence your worship will find at page.
Will admit.
My lord,
Will admit.
I'll also pray for an interim, my lord.
Not possible without. Statutorily not possible. Statutorily. Because public prosecutor has to be given the opportunity. Law is laid down to that effect. More particularly when it is POXO.
Very, my lord, because the case, the wife is, my lord, held to be a minor, based on some presumption from what they are doing today. That is the case, my lord.
Okay, we'll issue notice, we'll consider, we'll ask, we'll issue notice in the IA also. We'll consider it on returnable date. Heard Mr. M.K. Chodri, and Senior Counsel, stated by Mr. Learned Counsel for the accused appellant and Miss S.H. Bora, learned additional public prosecutor for the respondent number 1, State of Assam.
Then please for the six.
This criminal appeal under section 4152, Bharatiya Nagarik Surakha Samhita is presented against a judgment dated 4/4/2025 and an order on sentence dated 8/4/2025 passed by the Court of Learned Additional Sessions Judge, Special Judge, POXO, Kamrup, Metro at Guwahati in Sessions SPL case number 263 of 2023, arising out of Dispur Police Station case number 202 of 2023. So by the judgment and the order on sentence, the accused appellant has been convicted for the offenses under section 9, Prevention of Child Marriage Act, and section 376 or Indian Penal Code, and section 6, Prevention of Children, Protection of Children from Sexual Offences Act 2012. Full stop. In view of section 42 of the POXO Act, the accused appellant has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 2 lakh, in default of payment of fine, to undergo rigorous imprisonment for another 2 years under section 6 POXO Act. Full stop. For the offense under section 6 of the Prevention of Child Marriage Act, he has been sentenced to undergo rigorous imprisonment for 2 years. Concurrently is not there.
It's not there, madam.
Okay, 20 plus 2, that means. Okay. We have gone through the contents of the nine.
Section 9.
We have gone through the contents of the memorandum of criminal appeal. The criminal appeal is admitted for hearing. The case records of special case number 263 of 2023 we call for. You should notice returnable in 4 weeks. As MS Bora learned additional public prosecutor has appeared and accepted notice. Like this direction. Response number 2. Additional public prosecutor from the officer in charge, Dispur Police Station. I heard Mr. M.K. Chodri, and Senior Counsel, State President, so Learned Counsel for the petition for the applicant appellant, and Ms. S.H. Bora, Learned Additional Public Prosecutor for the opposite party, just response number 1, State of Assam. The instant application under section 430 within bracket 2 of the Bharatiya Nagarik Surakha Samhita 2023 is preferred seeking suspension of execution of the sentence passed against the applicant appellant and for his release on bail. Post of the applicant as the appellant has preferred the accompanying criminal appeal, criminal appeal number so and so, against the judgment so and so, so and so. Issue notice returnable in 4 weeks. As Ms. Bora has appeared accept. Opposite party number 1, applicant appellant will take stage for service of notice upon the respondent number. Opposite party does respond number 2 by registered post. By practice direction. Okay. The additional public prosecutor shall file its objection to the instant application on or before the next date of listing. Where will be considered after receipt of the LCR and TCR and filing of the objection.
Obliged.
Item number 5.
It is a lot.
Offense
Offense is malad, sentence is passed under section 376, that with section 6 of the POCSO Act malad.
hired Mr. M.A. Chaudhary, learned counsel for the accused appellant, R.R. Prosik, learned additional public prosecutor for the respondent number 1, state of Assam. This criminal appeal under section 415, no? BNSS is presented against a judgment. An order dated 26/3/2025 passed by the Court of Learned Additional Session Judge FTC Sribhumi in Sessions Case number 32 of 2016, arising out of Pather Kandi Police Station Case number 180 2013. Posted by the judgment, an order dated so and so, the accused appellant has been convicted for the offense says under section 376 IPC and section 6 POCSO Act. Post in view of section 42 POCSO Act, the accused appellant has been sentenced. Oh, no. Okay, 42 nalai. The accused appellant has been sentenced to undergo rigorous imprisonment for how it is not matching, Mr. 376 and 6 POCSO.
Yes, POCS 376.
No, why 376? It is not matching. It could be 376 3, then only one sentence. If 376 is there, simpliciter, then 6 POCSO will not come. May not come. It could be either 376 2 something. For the offense under section 376 IPC, the accused appellant has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 10,000, with default stipulation. Post up. For the offense under section 6 POCSO Act, he has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 20,000, with default stipulation. Concurrent.
Concurrent is there, malad, it's page 39.
39.
Yes, page 39, paragraph 9. Yeah.
Okay. The sentences are to run concurrently. We have gone through the contents of the so. ML appeal is admitted for hearing. Case records of sensory call for issue notice as Mr. Kosik for 1. The accused appellant will take steps for service of notice among the respondent number 2. Informant in terms of the practice direction. The learned additional public prosecutor is to obtain report as it is service from the officer in charge, Mikir Pather Kandi Police Station. I hired Mr. M.A. Chaudhary, applicant appellant, R.R. Kosik, opposite party, that's respondent 1, state of Assam. The instant application under 4302. BNSS is preferred, seeking suspension of execution of sentence passed against the applicant and for his religion bill. The applicant has prepared the accompanying criminal bill, huh? I again issue notice, returning bill instruction, so. RR Kosik for opposite party number one, extra copy, 3 days, package direction, and objection.
The number 6.
Conviction is under 22C.
Okay.
Yes.
Hard Mr. D. Guzman. Learned counsel for the applicant appellant.
Three appellants.
Appellants. Applicants, appellants. And Mr. R. Kosik. Learned additional public prosecutor for the respondent state. First of the present criminal appeal is preferred under section 336B, Narcotic Drugs and Psychotropic Substances Act, right, with section 4152 BNSS against a judgment.
Judgment is 3/5/2025. 3/5.
Where is the 3/5/2025 passed by the Court of Learned Special Judge within bracket NDPS, Karbi Anglong and Difu in NDPS case number 6 of 2023. By the judgment and order dated so and so.
Sentence is dated.
Okay. And an order on sentence dated 7/5/2025, right?
Yes, ma'am.
By the judgment and the order on sentence, the accused appellants have been convicted for the offense under section 22 within bracket C of the NDPS Act, and they have all been sentenced to undergo rigorous imprisonment for 12 years each and to pay a fine of rupees 1 lakh each, in default of payment of fine, to undergo simple imprisonment for a period of 1 year each. First of all, we have gone through the contents of the memorandum of the criminal appeal. The criminal appeal is admitted for hearing. If the case records of NDPS, case number 6 of 2023, be called for, issue notice, returnable in 4 weeks as Mr. Kosik with the peer accepted. Respondent Nair, 2 Nair. Is the case of reports.
Even
I.
Notice may be issued.
Hard Mr. V. Goswami, correct. Counsel for the appellants, RR Kosik, learned additional public prosecutor for the opposite party, first respondent from a state of Assam. The instant application under section 4302 BNSS is prepared seeking suspension of execution of the sentence passed against the appellants and for their religion bill. The applicants as the appellant has preferred the accompanying criminal appeal in issue notice objection.
I got 7.
Yes,
Yeah,
offense
6 of the POSCO
6.
and 440 rifles.
Heard Mr. N. Mahajan, learned counsel for the accused appellant, and Mr. R. Kosik. 415, BNSS. Judgment. An order dated 10/4/2025. Court, additional session judge comes special judge within bracket POXO, Moringao, arising out of Lahori Ghat Police Station case number 181 of 2022. By the judgment and order dated so and so, the accused appellant has been convicted for the offense says under section 6 POCSO Act and section 448 IPC. First of, for the offense under section 6, the accused appellant has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 20,000, with default stipulation. For the offense under section 448, IPC, he has been sentenced to undergo rigorous imprisonment for 3 months. Most of the sentences are ordered to run concurrently. We have gone through the contents of the memorandum of criminal appeal. The criminal appeal is admitted for hearing. The case records of so-and-so be called for, issue notice, returnable in 4 weeks, as Mr. Quashing, so that we had accepted. What is the response number 1? Issuance of formal notice dispensed, extra copy with working days. The accused appellant shall take steps for service of notice upon the response number 2, press informant in terms of the practice direction. The learned addition public prosecutor is to file, release the case after 4 weeks. Is to obtain a serviceable officer in charge. Mistake.
There's a I in.
Mr. N. Mahajan, learned counsel for the applicant, and Mr. R. Kosik, opposite party, that's response number 1, state officer 4302 BNSS. It's filed seeking suspension of execution of the sentence passed against the applicant appellant. And for his release on bail, the appellant has prepared a accompanying criminal appeal. Sentence, issue notice, returnable in so-and-so, as Mr. Procedures appeared and accepted notice. For the opposite party, that's response number 1. Formal notice dispensed with 1 extra copy. 3 working days. Applicant appellant shall take steps for service notice. So the response opposite party, that's response number 2. In terms of the practice direction, the line direction of the prosecutor is to file objection on behalf of the state to this instant interlocutory, to the instant application on or before the next date of listing.
Item 8.
May I please, Lordship?
Yes.
Lordship,
Will issue notice admit?
yes, Lordship, actually the current situation, the present respondent is the permanent resident of Manipur. And the current volatile situation in the Manipur. So, and the this respondent is in Guwahati Central Jail. And for another case. So Lordships may kindly allow us to serve the notice in the Central Jail.
Okay. Heard Mr. D.
D.
Bharadwaj.
D. Bharadwaj.
Learned counsel for the appellant, NIA. This appeal under section 21 within bracket 4 National Investigation Agency Act 2008 is preferred against an order dated 18/6/2025 passed by the Special Judge, NIA, Assam at Guwahati in bail petition number 486 stroke 2025 by the order dated 18/6/2025, the learned special court allowed the bail petition preferred by the respondent aggrieved thereby, dissatisfied with and aggrieved thereby, comma, the instant appeal has been preferred. Close the. Mr. Varad was learned counsel for the appellant NI has submitted that the respondent is a permanent inhabitant of the state of Manipur. Full stop. However, comma, the respondent is presently lodged in
What is central jail? In another case.
Central Jail, comma, Guwahati, in connection with another crime case. Postal. So, but you take also step by registered post
Yes.
apart from that.
Yes, sir.
This we've gone through the contents of the memorandum of appeal. The criminal appeal is admitted for the appeal is admitted for hearing. Do you need scan copy or what?
Yes, sir.
Hmm?
Yes, sir. It can go.
Issue notice returning bill for this.
Lordship, 2 weeks.
We are having 2 weeks holidays. We treat everybody same. All 4 weeks.
Lordship,
Notwithstanding it is a NICS.
Lordship, I have one more prayer. In page number 3 in our criminal appeal, there is a typographical error. Page number 3.
You approach the register judicial, I'll observe
Yes, Lordship.
the appellant shall take steps for service of notice upon the respondent by at the address by registered post at the address shown in a memo of appeal by registered post with AD Quincy of English post of. In addition, comma, the appellant is permitted to serve the notice when the respondent who is stated to be presently lodged in the central jail Guwahati in personally, and thereafter to submit a compliance affidavit to that effect. Full stop. The scan copies are you? Huh? Scan copies of. What is the case number? RC.
RC 5/24 slash.
It will be voluminous, I think.
Yes,
Hmm?
Lordship.
Voluminous.
Not much.
Okay. It is running page 17 or so. RC dash 05 stroke 2024 stroke NIA dash IMP. We call from is so and so. Mr. Vardas has submitted that a typographical one or many
Only one.
a typographical error has crept in at page 3 of the memo of appeal. Post of he has sought leave to correct the same post of. The typographical error is permitted to be corrected. Permitted for correction before the registrar judicial.
Obliged.
The 9 orders.
Service 2 is complete. None appears. None appears. Service. Oh, you have appeared. Okay, you have been appointed. Would you want to file any objection? Okay. After vacation?
Yes, ma'am.
Heard Mr.
Yes, Sharma.
S. Sharma. Appeal লিখিব Learned counsel for the appellant. MS A. Begum, learned additional public prosecutor for the respondent number 1, State of Assam. And MS R. D. Mojumdar, learned amicus curiae for the respondent number 2. That's here you said. He's here. Yeah. The case records from the trial court have been received. The registry to prepare the paperwork. Release the case after 4 weeks for a report as regards readiness of the paperwork. Post of IA S. Sharma, appellant A. Begum, learned so for the opposite party, yes, respondent number 1, State of Assam. R. D. Mojumdar, learned amicus curiae for the opposite party, that's respondent number 2, informant. Post of MS Begum has submitted that an affidavit on behalf of the state has already been filed. And the same is on record. Full stop. Ms. Mojumdar learned amicus. Learned amicus curiae paying for the opposite party, the respondent number 2 has submitted that she would rely on the objection file on behalf of the states in respect of the instant application. First of as sought for and has agreed to by the learned counsel for the parties to be the case after 4 weeks. And the consideration will be given to the instant application on the next date of listing. How many witnesses? Which copy?
Yes, ma'am.
You give the copy.
Deeply obliged, ma'am. Item 10. Mayor, please look. Amicus may be appointed now. Service is complete.
Paperwork ready.
29(5) order is there.
Heard Mr. N. Mahajan, learned counsel for the appellant and appellate. Ms. A. Begum, learned additional public prosecutor for the respondent number 1, State of Assam. Post of. As per
It's ordered at 29(5)/2020.
okay. Despite service of notice upon the respondent number 2, that's informant, none has appeared to represent the respondent number 2 as informant till date. Post of. In view of such non-representation, we deem it proper, in the interest of justice, to appoint Mr. D.K. Boydo, learned counsel, from the panel of, I guess, to represent the respondent number 2 in this appeal. First of, a copy of the registry to furnish a copy of the paper book to Mr. Boydo, learned amicus curiae within a week from today. Stop.
The IA and the objections are not filed.
I N. Mahajan for the applicant. Appellant. A. Begum, land additional public prosecutor for the opposite party, that's respond number 1, State of Assam. And Mr. D.K. Boydol, learned amicus curiae for the amicus curiae who has been appointed today to represent the respondent number, opposite party, that's respond number 2. That's informant. Full stop. You'll get the copy of the paper book, so you can prepare your eye, both of you. How much time? The as sought for, both the respond opposite parties, the land counsel for the opposite parties are allowed. How much time? 4 weeks time. 2 weeks holiday. 4 weeks time to file their objection to the instant application. Lays the case after 4 weeks.
Item 11.
May I please the motion? So as per office note, the service of notice of respond number 2 is complete.
Yes, madam. What is your explanation?
Possible is explain the page number, possible find page number 3, para 3 onwards. Okay? So the wife expired, the wife to the victim. And
Hmm?
here the
What is the offense?
302. Also.
302
Who's
on
February,
committing murder of his wife.
this is the allegation. Absolutely the false.
That is a
This is the allegation. Also.
one court has returned a verdict of guilt.
Yes.
So presumption is gone.
This is the allegation.
Principle of criminal jurisprudence, and a person is presumed to be guilty, or presumed to be innocent. That is gone. Heard Mr. P.P. Borthakur, learned counsel for the appellant, and Ms. A. Begum, learned additional public prosecutor for the opposite party, that's respondent number 1, State of Assam. Full stop. We have perused the report forwarded by the Chief Judicial Magistrate, Dibrugarh. Report dated 3/4/2025. Forwarded by the Chief Judicial Magistrate, Dibrugarh. And report of the process server annexed thereto. Full stop. As per the report of the Chief Judicial Magistrate, Dibrugarh, addressed to the SN Register 1, High Court. GSC, hello. The notice has been, service of notice has been duly affected among the respondent opposite party, that's respondent number 2. Full stop. The instant application under Section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 654 days, which have occurred in preferring the accompanying criminal appeal under Section 415. two, Bharatiya Nagarik. Bharatiya. Yep. Mistyped.
Sorry.
Bharatiya Nagarik. No, in the criminal appeal, Nai Honita, there is equivalent to Evidence Act perhaps. Nagarik Kurotka Honita 2023. Post of the accompanying criminal appeal is preferred against a judgment dated 6/2/2025 and an order on sentence dated 10/2/2025. 23. We got 23. We got 23. Post of by the judgment dated 6/2/2023. The appellant has been held guilty of the offense under section 302, Indian Penal Code. Post of the appellant by the order on sentence, the appellant has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 3,000, in default of payment of fine, to undergo simple imprisonment for another month. Full stop. We have gone through the statements and awareness made in the instant application, more particularly, paragraph 3, 4, and 5. What's the litigation? It has been averred that after the conviction and sentence, it has been averred that the mother of the appellant has been suffering from paratriculic acid, paroxysmal supraventricular tachycardia, congestive heart failure. And after the conviction of the appellant, she had to undergo medical treatment for her ailments. Also, as the appellant has only 2 minor children apart from his mother in the family, the an appeal could not be referred in time. Post of. You were legal aid or what?
No.
Ah. It was the mother could ultimately prefer the appeal on Budget. 5/3/2025, full stop, in the process, comma, the delay of 654 days have occurred. Full stop. Para. Having regard to the statements and affirmations made in the instant application, we are of the considered view that the applicant appellant has been able to explain the period of delay of 654 days, showing sufficient cause. Full stop. Moreover, comma, since the applicant appellant has been sentenced to undergo rigorous imprisonment for life, comma, we are also of the considered view that the accompanying criminal appeal is to be heard on merit. No, sorry, consider view that in interest of justice will be better subserved if the accompanying criminal appeal is heard on merits, leaving aside any technical consideration. First of, the applicant appellant is in incarceration since sentenced since 6/2/2023. Also, for the proceedings, the instant application seeking condonation of delay of 654 days in preferring the accompanying criminal appeal is allowed. Restrict to register the accompanying criminal appeal and thereafter come to release the same for admission.
Item 12.
Heard Mr. A.R. Karim, learned counsel for the applicant. Full stop. The instant application under section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 31 days in preferring the accompanying appeal under section
19.
we need to make it 1 of the Family Courts Act 1984, read with section 28 of the Hindu Marriage Act 1958 against a judgment and a decree dated 1/8/2024. Issue notice returnable in 4 weeks. The applicant shall take steps for service of notice upon the sole opposite party by registered post with any within 3 weeks. Yes, the case of the courts.
Hello, I am appearing on behalf of Mr. N.J. Das, my lord. He has some difficulties today, my lord. Item number 17, my lord. It may come up on, my lord, 14 July, my lord, because the lower court date is on 17th, my lord.
Okay. On the prayer of Mr.
I am Mr. S.M. Mullah, my lord. On behalf of,
S.M. Mullah, learned counsel, appearing on behalf of Mr. N.J. Das, learned counsel for the petition, release the case on 14/7/2025, 17.
May it please
Yes.
your lordship. Lordship, in connection to supplementary list item number 20, lordship, I had filed an IA yesterday to implead the informant, my lord, on instruction from my client, to implead the informant as responsible.
Okay.
Lordship, that may be called. Obliged.
I believe the lordship, I get to mention item number 22. Pass out.
22 on the prayer of Mr.
I stumble.
I. Islam, learned counsel for the petitioner. The case is passed over for the day. Ms. A. Begum and additional public prosecutor for the state is in attendance.
Yeah, please, Your Worship. I make mention item number 3 of the daily list. Worship.
3,
Worship.
okay,
That may be
Yes.
adjourned for the day. Worship.
huh?
Adjourn.
Adjourn for the day.
Worship.
On the prayer of Mr.
I mean, Worship.
Then counsel for the petitioners. The case is passed over for the day. A. Begum is in attendance.
A date may be fixed after vacation. Worship.
Release the case on 16.
Worship.
Lordship, item number 16, Lordship. Lordship, matter may be adjourned for the day, Lordship. And
On the prayer of Miss.
A. Pine.
A. Pine. Then counsel for the petition, the case stands adjourned for the day. A. Begum.
It is for, I don't know one.
Wait, please, Your Lordship.
Hmm.
Lordship, the matter has become infructuous, Lordship.
Mr. S. N. Kisna Troyer, learned in counsel for the petition, has submitted that in view of an order passed on 6/6/2025 by the learned Judicial Magistrate First Class Kamrup Metro Guwahati in CR case number 7554/2022. The subject matter of the instant criminal petition has become infructuous. Mr. Kisnatra has placed a photocopy of the order dated 6/6/2025, which is to be kept with the case record. Ms. A. Begum and additional public prosecutor in attendance. In view of the above submission made by the land counsel for the petitioner, the criminal petition stands closed as infructuous.
Item 2.
Person is every person against the order also, but they have.
Call for report.
Receive it, give it a bit of, we have got to this.
Item number 4.
Petitioner, liberal lordship, is the brother of the deceased man. My lord, his brother, who expired, my lord, was traveling with his wife. But first FIR, my lord, the petitioner lost against the driver, saying that the driver made an accident. But thereafter, they came to know the entire allegation is against the wife of the deceased. Because some documents I have annexed, my lord. So another complaint case filed by the petitioner, explaining every action circumstances. That is, lordship may kindly come. So page number, let me 3 relevant portion, my lord. Page number 3.
So this petitioner filed an FIR. Let us see the FIR first.
So my lord, first FIR page number, page number 9.
Who is the petitioner here?
Here petitioner is the
Jonathan Borua.
petitioner. Jonathan Borua was the
Humble.
number 14 is available.
Okay, petitioner's brother expired.
Yes, my lord.
Okay, then case registered.
My lord, lordship,
279-279-304A. Okay, what was the result of that
My lord,
investigation?
my lord, page number 17. Very
17.
seen for a moment, my lord. 17.
17.
Final report.
Final report.
Final report.
Yes, what is
So,
the
my
final
lord,
report?
Yes, my lord,
What
the
is the-
petitioner is agreed by final report.
What is the comment there?
My lord, final reports comment, lordship may kindly see the
Photo পোস্ট করে জানিব পৰা যায়
20
দিনা এটা গুৱাহাটীত আছিল So for the driver, it is alibi. So this was driving the vehicle.
Yes. But why he has been.
Okay,
Right.
then this was this notice was
Okay.
given to you?
Yes.
Notice or the final report was given
Yes,
to you?
yes.
Okay, what
Page
did you
24.
do? Let us take, let me take, please take me to the document.
My-
Hmm. So notice was given to you or not?
Yes, my lord.
Huh. Then what did you do?
My lord, I submitted a Naraji petition, my lord, my lord, a complaint case.
Oh, where is
Yeah.
that?
My lord, before that, one page number is there, my lord, page 24. Page 24,
Hmm.
this is the report, my lord. In the column number 6 may be seen for a moment, by what weapon inflicted, blunt weapon. So we suspect that he was killed, my lord, by blunt weapon. Now, your lordship may kindly come to complain what I did, my lord. Page number 25. This was submitted before the Civil Judicial Magistrate Dhamaji, page 25. And the accused here is the wife, my lord. And the case is submitted, my lord, under section 302 IPC. This was a murder, my lord. Page 25.
Yes, madam. After 2 years,
Right side of the vehicle. Left side is looking.
everything is on suspicion. It is a region order. And you should notice at this stage. Heard Mr. A. Ali. And counsel for the petition. And Ms. A. Begum. United Edition of Public Prosecutor. For the respondent state. First of this criminal petition. Under section 528 BNSS 2022 is prepared against an order dated 5/4/2025 passed by the learned Chief Judicial Magistrate Naraji in a complaint is CR number 78 of 2024. First up, by the order dated 5/4/2025, the complaint filed by the petitioner on has been dismissed. First of it is stated that the petitioner's brother, while traveling with his wife, on 5/8/2022 from Dibrugarh to Tejpur in his own vehicle, met with an accident at Gerua under Silapatra police station. First of all, in connection with the death of the petitioner's brother, the petitioner had earlier lodged an FIR on 14/8/2022 before the officer in charge, Silapatra police station. And the said FIR was registered as Silapatra police station, case number 147/2022 under section 279/304A from IPC. After investigation, so the FIR, 1 Nirmal Borua was named as the accused, alleging arrest and negligent driving on his part. So stop. After investigation, Silapatra police station case number 150 of 2022 had resulted in a final report number 150 of 2022 on 28/9/2022. Finding no case made out against Nirmal Borwa. Post. When did you file your Naraji petition? When did you?
My lord,
No.
12/9/2024, page number 32, my lord.
When notice was issued, sir? On the final report? Because we have to see the abuse or the process angle also. When did you prefer the Naraji petition? When did you receive the notice? Because final report was submitted on 12/9/2000 or 28/9/2022,
My lord,
right?
my lord.
When did you receive the notice from
that-
the trial court
That instruction,
regarding submission of the final report?
I have to obtain the instruction.
You better
I
obtain.
will explain.
Because after 2 years, suddenly you have wake up from deep slumber, and that too on suspicion, then it might be misuse of the process. Come to page 17.
My lord,
Final report was on 28/9/2022,
my lord,
right?
my lord.
So notice must have been given to you before acceptance of the final report,
Definitely, my lord.
right? And if you see, compare that with page 25, and it is 12/9/2024.
My lord.
So what did you do for last 2 years
2 years.
in between? I'm not very satisfied with your delayed act of submitting the complaint.
There is a delay, my lord.
Absolutely.
I will explain it. My lord.
You explain it.
I will explain.
Otherwise, from the complaint petition of complaint case number 78/2024, annexed as Annexure E to this petition, it is noticed that the complaint was filed on 12/9/2024. Full stop, para. It is ordinarily, when a final report is submitted, finding no prima facie case against anyone, the informant is given notice by the learned court, by the jurisdictional court, before acceptance of the final report. Full stop. As the final report is of 28/9/2022, and the complaint petition was filed on 12/9/2024, the petitioner has a duty to explain.
My lord, that explain, my lord, I have find out, my lord. Lordship.
You have to find
For-
out, has to
my lord.
explain
Page number 30.
the delay,
My lord,
which
delay.
document,
My lord,
statement, Naraji petition.
yes, in the Naraji petition, page number 34, para 9 may be seen, my lord. Page number 34, para 9, I am going to see the vernacular, my lord. Page number 34, para 9. Some complaints were also made before the authorities, my lord.
After September 2022, right?
My lord,
What did you do?
yes,
When you received a notice regarding submission of final report, then your reaction to the final report, then whether you appeared or not before the jurisdictional court to file a Naraji petition, protest petition, right? And thereafter, there are many ways to treat it.
Yes.
Right?
I
That
will,
protest petition can be treated as protest petition. Then protest petition without accepting the final report, or protest petition can be treated as a complaint after accepting the final report because you have alleged and you have projected a new angle. Now, earlier you implicated the driver. Now you implicated the deceased wife. So it could be treated as a complaint, right? Separately.
Correct.
For that 2 years delay, you have to explain.
Right.
And everything is on suspicion. Everything is on suspicion. You have to explain. Just because bad relation you cannot implicate. Mr. Ali, the counsel for the petitioner has sought 2 weeks' time to bring on record the so submitted for 2 weeks' time to obtain further instruction as regards the period of delay in filing the complaint petition on 12/9/2020. So, list that is, the prayer is allowed, list that is.
Timing method, I don't know what to. May play a lot.
Will not break the line.
I don't know, 5.
Timing also, this matter will pass off for timing also. Let's say petitioner be approached this honorable court only because if the petitioner got married to respondent number 2. Petitioner got married to respondent number 2 in 2022. Let's say thereafter, because of some information given by one lady, let's say there is a difficulties between the petitioner and the respondent number 2 to live together as husband and wife, because the wife of a person has informed the petitioner that his wife is maintaining a relation with another doctor. Wife is also doctor. Relation with Dr. Wasim. After that, let's say there is a adjustment difficulties. She came back to Guwahati. Petitioner is a computer engineer. He is residing at Bangalore. Thereafter, the wife returned to Guwahati. She is practicing at Marwari Maternity Hospital at Guwahati. In 2022 September. Thereafter, she filed an affair in 2024 before the family court, before the Parliament police station, alleging 498A, alleging against the husband, against the father-in-law, mother-in-law. After filing affair, police has called the petitioner from the Bangalore. Police has called, petitioner has come to the Parliament police station. And after that, police has taken statement of both the person, as well as the person accused by the petition. And thereafter, there is a settlement between the parties that they will make a mutual divorce. And she has withdrawn the affair. I'll show the document. After that, Lordship, she has filed a case, in divorce case in the court of family court at Guwahati. After that, she filed a case under section 498 again. Under the Domestic Violence Act in the court of CGM. Police has, honorable court has registered the case against the mother-in-law, father-in-law, and the petitioner under Domestic Violence Act.
So you want to say that initially FIR was lodged under section 498A IPC by the respondent number 2 against the petition. So ultimately it was withdrawn.
Withdrawn,
It was not registered.
not registered,
Not registered.
not registered.
Meaning thereby, police cannot withdraw an FIR.
She has withdrawn.
She has withdrawn. So it was not registered at that point of time.
Thereafter, she filed a complaint petition under section 498 before the Honorable
No,
2024.
in between you said divorce. When? Sequentially.
Lordship. Thereafter, she filed a case with divorce in the Court of Family Court at Guwahati. Thereafter, she
Which
filed.
one? Which one?
Lordship will find page 38.
Page 38. Okay, it was in which
2024.
2024. So in and around February.
February.
February. Okay, February.
Thereafter, she filed a case under section 498, a complaint
This
case
is ground on what ground?
on ground of Lordship cruelty and
Cruelty.
cruelty. Ultimate,
1A. Cruelty.
Cruelty.
Okay.
thereafter, she filed a complaint case in the court of CGM under section 498A. Honorable Court, after getting the information that earlier there is an affair,
No, you just a minute, proceeding of family court and you filed written statement.
Lordship,
When?
written statement at place 46,
When the date?
April 2024.
April 2024. So February, divorce petition was filed. Right?
And April, we have filed the reply, WS.
With WS, where is the end of it? Okay, April you filed written statement,
Lordship.
right? Thereafter,
Thereafter, she filed a V case in the court of
when?
in 2024. That is, we have notice on May 2025,
February, at the same time.
May 2024.
No, is,
We have received notice page 66.
and petition
Petition is Lordship will find at page
67,
67.
and affidavit
I have
February, same
Lots of-
time perhaps.
on 24th May, notice has been issued, page 66.
66. Otherwise, page 78,
Lordship,
because it appeared to be February.
Lordship.
I don't know that it is correct or not.
Ultimately, notice has been issued on, Lordship, I have received notice on after May, Lordship. Notice at page 66, Lordship.
What is the procedure in DB? Sorry, this is DB. What is the procedure DB case?
DV case,
How? That like a complaint case?
Like a
Initial
complaint case, there is
statement,
a-
Initial
there
deposition.
there is a report from the officer regarding the domestic violence
Ah.
and everything. Thereafter, court take the cognizance. I'm not on that now, Lordship.
No, I want to know. You may not be on that.
Protection officer giving a report. Protection officer giving a report regarding domestic violence, and thereafter court take the cognizance.
Then thereafter only court takes cognizance. Okay, so this delay may be attributed to them, might be attributed to that, might be. I'm saying might
I'm not
be,
on that, Lordship. No. I'm not on that, Lordship.
but I want to know.
Lordship.
I am not as
I understand, Lordship. Lordship is-
familiar
Lordship.
with the DV procedure as like you,
Lordship.
right?
Lordship, domestic violence case was registered and we should notice.
Okay, that
Against
is
the
that is in May.
Lordship, offense has been, alleged offense has been committed at Jorhat and Bengaluru. This case has been filed at Guwahati. Domestic Violence Act has case has been filed at Guwahati. The jurisdiction point or other things.
You never stayed in Guwahati.
No. Marriage took place at Jorhat. We stayed together at Bengaluru as a husband and wife for 5 months.
Not even a single
It's not a single day.
occasion. Okay,
Lordship. Thereafter, Lordship, she has filed another complaint case under section 498A.
Hmm.
That is page 89.
yes.
Notice has been received page 88 on 24th November 2024. Page 88.
When it was filed?
It was
Any
filed,
idea?
it was filed on 23/2/2024 as per Lordship filing slip,
Same, on the,
Same.
or in and around the same time.
same time. Lordship, thereafter,
Notice is, I think, 406.
CR
This case, this C 88 notice
Page 88 also.
Offense 406.
40634.
Yes. Though in the complaint, it is 498A. Offense is 406. Notice.
Some mistake has been committed.
No, mistake may be one thing. Maybe for properties,
I will take the cognizance. I will say the order of cognizance.
because yes, please. Because
Lordship,
someone.
Page 89, Lordship, 498A.
Page.
Page 89. 498A, oblique 34.
Page 89.
Nine.
That I have seen.
Lordship.
CR case number 140. I have seen. Then come back to the previous page, page 88.
Lordship.
But notice has been issued.
40634.
Right. That is why I am asking.
How proceeding is going on, Lordship?
No, but maybe because of this is a complaint case.
Lordship.
Initial deposition has to be recorded previously under section 200. If more inquiry 202. Thereafter, process will be issued 204. And the offense made out will be entirely within the discretion of the magistrate. Right. So how it is from 498A, how it has got translated into 406?
Because, Lordship,
No, for that purpose, we have to see. You have to.
Lordship, now I am under 406 now. I will place another case where 406 has been filed. Now in 406, I am approaching this honorable court.
This you are against this page 88 notice.
No.
But proceeding.
Now
No, you are against which proceeding?
105 now.
105.
Against 406 petition.
You mean to say, this was also in February 2024. February 2024, 4 cases. One for dissolution of the marriage. Second is DV.
Case.
Third complaint case is 498A. Fourth is under section 406.
406.
And whether a process has been issued,
Lordship, that is violence.
let us see. In the fourth case,
124.
where is the process in the fourth case?
Lordship, will kindly say before that, may I take your Lordship to some other things also?
No, process in the process issued in the fourth case.
Court case is at page 125.
120. No, this is order taking cognizance,
Lordship.
right?
Lordship.
And issuance of process, that is in 26/9/2024. Right?
Page 86 is the notice, Lordship.
Huh?
Page 86 is the notice.
Okay. (17)2. 27. Before the same court or different courts?
The Lordship,
Same
court.
court.
Different.
No, same court. If we see page 87,
Lordship, D. Roy SDGM,
Hmm.
JMFC.
JMFC, same.
Yeah.
Same. 202 406. And 87. 406. 7406. 406. Yes, Mr. Kosik, how do you reconcile this?
Before that, Lordship, can actually see one thing. I actually saw real Lordship. Page 32. Page 32. This is a letter to the officer in charge by the respondent number 2. Lordship got it. Handwritten copy is page 33.
What is the content?
Contently, Lordship, they, both the parties, my parents, along with he and his father, in front of Tinkul Goswami, attended this meeting in December. The discussion, we came to conclusion that mutual divorce in certain terms and conditions. Now, page 34. Both the parties have signed before the officer answers. For amicable settlement. Now, all these cases has been filed only to harass the parents as well as the petitioner, to drag the petitioner from Bangalore to Guwahati and his parents. And Supreme Court has categorically stated in a recent judgment in 2025, filing different cases, criminal cases, without disclosing the other cases against the same accused. Because Lordship, street on and other things, he can approach the family court itself. If there is a street on with me. She is filing different cases only to drag the petitioner to Guwahati, filing three different cases in different dates only to drag the petition. And Supreme Court
So,
is getting
one is
DV,
dissolution of, for dissolution of marriage
lots of divorce
on the ground of cruelty.
cruelty,
Second is DV.
DV,
Third is 498A 34.
34.
Fourth is 406. 406. So 498A, 406 can go together in one complaint itself.
One complaint.
Why two complaint then?
It is only harassment, Lordship. Supreme Court has categorically stated in 2025 that filing different cases, criminal cases against the same person, against the parents, only to harass the petitioner, Supreme Court has quashed all these cases. And marriage took place at Jodha.
And cause of action may, I don't know, 177 onwards. Because so far cause of action is concerned, there is some
dispute
liberty
wife, in case of wife.
to the wife. Anyway, which would have been included in 498A complaint. There ought to have been the same complaint in and around the same time. 406 and 498A in and around the same time before the same court, but two complaints. This appears to be not proper from the standpoint of the accused. He can face one proceeding, why two proceedings? Yes, advice. Legal advice. Hurt. Will state a further proceeding of 406. In the month of February, everything? 2024? Okay. Heard. Mr. S. K. Goswami, learned counsel for the petitioner. Mr. R. R. Kosik, learned petition public procedure for the respondent number 1, State of Assam. First of all, para. The petitioner has projected that the marriage has entirely projected that the marriage between the petitioner and the respondent number 2 was solemnized at Jorhat on 22/4/2022. Post of. Thereafter, they started their conjugal life in the working place of the petitioner at Bangalore. Post of para. Initially, a complaint was lodged by the respondent number 2 before the all women police station. When?
On to 24, Lordship. Please.
In 2024.
24 without.
And after and officer in charge all women police station summoned both the parties. Post of in response, the petitioner appeared in all women police station. Also, it is stated that the matter was shown to be amicably settled on after the respondent number 2 submitted a letter to that effect with signature of both the parties, signatures of both the parties.
Initially,
And post of thereafter, a letter was submitted with signatures of both the parties on
19,
page 35.
page 35,
On
19 to 2025,
19 to 2025.
24.
20 post of para. But immediately thereafter, in the month of February 2024, the respondent number 2 instituted 4 cases against the petitioner as under one. First one,
First one,
divorce.
page 37.
37. FC Civil Case number 219/2024 before the Court of Principal Judge Family Court, Kamrup Metro, Guwahati, page 38. Under section 13(1) small 13(1) bracketed, 1 bracketed, small IA of the Hindu Marriage Act 1955, seeking dissolution of the marriage by a decree of divorce. 2. Second,
Page 66.
66.
It is
Miss DV case number 80/2024.
30 of 24.
30 of 2024 before the Court of Judicial Magistrate First Class, Kamrup Metro, Guwahati, under section 12 of the Protection of Women from Domestic Violence Act 2005. Third, 3. Complaint case number 140/2024 before the Court of Judicial Magistrate First Class, Kamrup and Guwahati, under section 498A/34 IPC. 4. Complaint case number 146/2024 before the Court of Judicial Magistrate First Class, Kamrup Metro, Guwahati, under section 406 IPC. Post of para. Mr. Goswami, learned counsel for the petitioner, has submitted that the respondent number 2 has submitted the aborts mentioned had submitted multiple cases against the petitioner, as mentioned had invoked. Also, he has further submitted that the to bring in the allegations of the offenses under section 498A and section 406 IPC, both IPC, APC. The respondent number 2 would have preferred one complaint, rather than two complaints before the same court. Postal. But, the respondent number 2 preferred to institute two complaints for the same cause of action before the same court. Postal. The said action is clearly suggestive of an act on the part of the respondent number 2 to misuse and abuse of the process of law and to harass the petitioner
And his family members. And his
and his family members in the aid of section 34 IPC, which is a part of the complaint of section complaint case number 140/2024. Postal. Issue notice returnable. The matter would require further consideration. Issue notice returnable in so and so as Mr. Quashing has appeared accepted. 1 extra copy, 2 working days. A petitioner shall take steps for service of notice upon the respondent number 2 by registered post with AD. Having regard to the projection made in the post-treated manner. So, while and counsel for the petition, I find primary force post of it is therefore ordered, in the interim, that the further proceedings of complaint case number 146C, upper C stroke 2024, presently pending before the Court of London Judicial Magistrate First Class Kamrup Metro at Guwahati shall remain state till the returnable date.
Item 7.
May I please, your lordship, this item may be taken along with item number 19, same arising out of same.
Okay, 19.
19 and 7.
We'll
same.
take 9 with 19.
Ah.
With 19, we'll take up both.
Lordship,
Both.
lordship,
You'll have enough time then to make submission.
no, lordship, lordship, the fact
No,
of the case is.
You are in a hurry.
No.
Oh, then we'll take up.
Item number 8.
Mistake on our part, that the impugn order by mistake was not annexed.
You annex it after filing additional affidavit.
My lord.
Mr. R.C. Soikia. Mr. R.C. Soikia as senior counsel. Listed by Ms. M.M. Das, Learned Counsel for the petitioner, and Ms. A. Begum, Learned Additional Public Prosecutor for the respondent number for the state, respondent state. Postal. Mr. Soikia has submitted that the inadvertently, the order which is impugned in this criminal petition has not been annexed. First of, he has sought leave to bring the impugned order on record by way of an additional affidavit.
Much obliged.
First of, he has thus sought for listing of the case immediately after the ensuing summer vacation. First of, the prayer made on behalf of the petitioner is allowed to list the case on a date immediately after the ensuing summer vacation.
Obliged, lordship. I am sorry, actually very rare mistake in my life.
5,000. I don't know how to translate. There is a proverb, Kerala and yes,
Petition for quashing of a criminal proceeding, Lordship. Lordship, petitioner before Lordship, he is the executive engineer serving in the Public Works Department. What has happened, Lordship, in the year 2020, through social media, Lordship, the petitioner came in contact with the victim, Lordship. Thereafter, they were in a.
social media.
Yes, they were in a relationship for 4-5 years, Lordship. Thereafter, the relationship could not materialize. And after the relationship broke up, Lordship, the informant, thereafter, after a gap of around 5 years, lost the FIR, alleged.
So there is not, at no point of time, their complainant must live in a shared household with the petitioner's madam. Because,
Where have you stated so?
my lord,
Where have you stated so?
when the
Where is the complaint, where
complaint is at page 21.
21,
Husband in law before lordship on the sister-in-law.
right?
As
No.
part of the,
How, what is the allegation made?
allegation that they are had just demanded money, husband demanded money from her.
No, against these two petitioners.
Because these two people, nothing specific is there, lordship, go through they accept that they
Please take
have
us.
abused, yes, lordship.
Wherever any semblance of allegation, please
Yes.
take us.
Yes, my lord.
Miss Begum, please go to the complaint.
I'm going.
Verbally abused.
Verbally.
That's all.
That's who it will attract.
Yes. Yes.
I think it's a relief can be claimed only against the husband when under this provision of the act. And she must live in a shared household with the petitioner.
Okay, where is your statement
Yes, ma'am.
that they live separately?
Yes, ma'am. In the grounds, my lord.
In the case, they are said as accused or what? Respondents.
They are actually the respondent.
No, their nomenclature is respondent.
Respondent.
Okay. Where you have stated they got married much earlier to the marriage of the was married. Okay, okay. I have got it before you. I have got
Sorry.
I have got before you. And when the this respondent was married, solemnized when? In the complaint might be. When it was solemnized. 2008. 2008.
2008 was the marriage month.
Madam, after 17 years, all this. Heard Mr. I.H.
I.A. Hazuri.
I.A. Hazuri. Then counsel for the petitioners. And Miss A. Begum, then additional public prosecutor for the respondent number 1, state of Assam. Most of this criminal petition under section 528. Oh, 528 second. B and S. S. Is preferred by the petitioners. Agreed by. Who is the someone?
Someone I have not annexed my lord.
Someone no, the order.
Order is there. And annex.
Agreed by
32.
an order
Please tell me.
dated 2/1/2025. Passed by the Court of Landing Judicial Magistrate First Class, Kamrup Metro, Guwahati, in DV case number 235 of 2024. Insofar as the petitions are aggrieved with that part of the order whereby the learned trial court had issued notices to them for to stand the trial in respect of prayer made by the respondent number 2 under section 12, protection of women from domestic violence act 2005 DV act or sort, wherein the petitioners hearing are arrayed as respondent number 2 and 3. Okay, full stop. The case projected by the petitioners is that the marriage between the respondent number 2, also respondent number marriage between the
One in the complaint.
respondent number 1 in the
Complaint.
DV complaint, who is a brother of the petitioners, and the petitioner in DV case was solemnized on 18/1/2008. Also, the after marriages of the petitioners on 24/4/2005 and 10/3/1996. Both the petitioners have been residing separately from their paternal house. First off, and as such, the allegations brought against the petitioners in DV case number 235/2024 are not maintainable. It is contained there. It is contained there. First of on perusal of the complaint, issue notice returnable in 4 weeks as Miss Begum, respondent number 1, State of Assam. The petitioners shall take steps for service of notice of the respondent number 2 by registered post with AD. On perusal of the complaint, it primarily appears that the allegation against the 2 petitioners, as married sisters of the husband, that they used to verbally abuse the aggrieved person. Oh, aggrieved person. Because I'm not very familiar with DB. Aggrieved person, that is one. Respond number 2, that's aggrieved person, but I'm supposed to clear it. First off, having regard to the nature of complaint made against the 2 petitioners in the complaint filed in DB case number so and so, it is ordered, in the interim, that further proceedings of DB case number 235/2024, insofar as the 2 petitioners are concerned, shall remain suspended till the returnable date.
One small correction we allowed to make, only instead of opposite party number 2, 1 is number 2, my lord. Collection.
Well,
The prayer access.
Mr. Hazarika has submitted, as Mr. Hazarika has submitted, that some typographical errors have kept in the criminal petition, he is permitted to do the necessary corrections before the registered judicial in his own handwriting.
Item number 11. May I please, Lordship? Lordship, here is a case, my lord, a sale deed was executed by the petitioner's father, and petitioner father purchased this plot of land in 2017. Once this property was developed, my lord, now one press reporter has paid us upon that property, and he, my lord, demanded certain amount that we have refused. Now, consequent thereof, my lord, he filed an FIR, my lord. He is a stranger, nothing to do with the transactions of my lord land, but he alleged certain thing that this transaction of sale deed is totally, my lord, not in accordance with law. Therefore, my lord, accordingly, my lord, the FIR was, my lord, registered. Page 44 is the FIR. And translated copy, my lord, in page 42. My lord, sale deed in page 21.
Sale deed,
Yes, is in 21,
21.
so duly executed. And thereafter, my lord, page
Sale deed, where is sale deed? What is the sale deed?
sale deed between my lord Rahul Jain.
Father, my son. Okay, father. Where is the sale deed of father?
Rajesh Jain, my lord, purchased this land from. my-
Where is the sale
Yes,
deed
my
of
lord,
father?
My lord, that is not in my lord Javandi copy.
Hmm?
In Javandi copy, it is mentioned, my lord. Page, my lord.
Where is
Deed-
that?
Deed was not there, my lord.
Oh,
It is a fact, my lord. I cannot, my lord, make a wrong submission. My lord, what happened that prior to that, the persons obtained this land in 2001, my lord. Since 2001, my lord.
you substantiate that you got the land
Yes, my lord.
by sale deed, because if it is Kosal Kumbhat,
Yes, Kosal Kumbat obtained
Ah.
this land in 2001, my lord.
right? So from Kosal Kumbhat, you have
Yes.
made the purchase.
Right.
Father.
Father, my lord.
Because father selling to son, that
Yes.
will be a suspicious circumstance. Unless father establishing that he had
Yes.
purchased it by valid means.
Let us take for a moment that Kusal Kumbhat has not executed the sale deed. For a moment, my lord. In 2001, Kusal Kumbhat entries in revenue records are there. Since 2001, position are maintained.
As
Nobody
per
of
order dated so and so, land measuring so. Mutated.
yes, my lord. In it was
Mutated.
mutated in the name of Kusal Kumbhat, my lord. That may lords may kindly see in page.
No, your Rajesh Kumar joined.
My Rajesh, my lord, page 15, my lord.
Kosal Kumbhat.
So therefore, my lord, what I am saying, my lord, there are two.
Can copy. Yes,
My lord, there only one prayer, my lord. Lordship, subject lordship. My lord, kindly see one Supreme Court judgment is very much clear on this point, my lord, that if there is no any transaction made, my lord, no deal made with the informant anywhere, my lord, he is a stranger, my lord. And that cheating.
Who? It
my lord,
appears to
informant,
be what
informant,
is the similar provision of 120B.
kindly see, my lord.
We
Only
are not.
one line, my lord, in absence of, my lord. That will depend on, I don't know, my lord, that will protect me.
No, if you are making interim prayer, I will make observation in the interim prayer.
My lord, to the,
After suspicious circumstance, 120B,
my lord.
it could happen. I'm making my
Then lordship,
intention
my
clear.
lord, lordship may first scan copy, my
I'm
lord.
making my intention clear.
Then lordship scan copy, my kindly.
Privacy observation, if you press for interim, I'll observe.
But there is a risky one. That burned my hand, my lord.
If you have taken bail, it is good enough.
Yes, yes,
We'll examine the matter. You have already taken bail, perhaps.
right, yes.
It is good enough to examine after getting the case diary. If you establish your credential, then FIR will go.
Yes.
FIR will go,
Yes.
obviously.
My lord.
But at this stage, because
Transform.
had the seller been not your father,
Yes, ma'am. Yes, ma'am. Then lordship Kusal Kumbhat, my lord. Kusal
then
Kumbhat.
absolutely you can make out a privacy case.
Lordship, may I see?
But
Madam, may I see?
heard Mr. S from Real and Counsel for the petitioner. and Ms. A. Begum, learned additional public prosecutor for the response number one state was the seeking quashing of setting aside and quashing of the criminal proceedings. Any PRC case?
Yes, my lord, the private respondent we made
No,
part.
no, PRC case. Miss Begum, what is the procedure nowadays? Any PRC case kind of thing?
Yes, my lord, the PRC case.
Why is that?
I'm giving one. My lord, that in contain, my lord, page 37, my lord.
Page 37. Page 37.
My lord, this is the first information report. Case number, my lord, I'm giving one. Yes.
Okay, likho. Bongai. Huh?
Yes, case number 125, 2025.
No, that is okay.
Yes.
Pangya Police Station, case number 125, stroke 2025. The instant petition. Under section 528 B and S has been preferred. First of Mr. Somalia has submitted that in the affair lodged on 20/05/2025, comma. The respondent number 2, this informant, had alleged inter alia to the effect that the petition and his father had adopting illegal means had purchased a plot of land in connivance with the revenue officials. First of, it is his submission that who is he? Respondent number 2. That's
My
informant.
respondent is a press reporter. He's
Is a stranger.
Submission mechanism.
Stranger to the subject plot. Also, moreover, comma, the petitioner's father had, sorry, in respect of the plot of land, subject plot of land, comma, the name of the petitioner's father was initially, it was mutated long back, and thereafter, comma, the petitioner purchased the subject plot of land from his father. Post of a matter of required examination, you should notice returnable in courts as Ms. Begum appeared accepted. 1. The petition shall take steps for service of notice of the response number 2 as informant by registered officer AD. Post of for consideration of the prayer for interim leave, comma, you will get scan copy. The learned additional public prosecutor shall obtain the scan copies, a scan copy of the case diary on the returnable date.
May we take step, Dusty service also to a respondent, that will.
Okay.
The registry will take, but Dusty.
Is it so? Okay. Scan copy of the case diary of so and so. Person be called for a copy of this order, registered judicial. In addition, comma, as paid for, comma, the petitioner is allowed to take steps for service of notice.
Right.
Respondent number 2 as informant by way of Dusty, which is to be noted to the registry. Compliance available.
Man. Item number 12. My lord, there is a case, my lord, pertaining to matrimonial dispute, my lord. Item number 14.
Please, Your Lordship. This criminal petition is filed for against the order dated 2/8/23, whereby non-bailable warrant has been issued against the petitioners. Page number 28, Your Lordship, the operative portion.
28.
There is the translated type copy, but the operative portion is at page number 29, annexure 3, lower part, handwritten. accused so and so and so and so are
Date order date.
order dated 2/8/23. The lower part, handwritten.
23 onwards, he is absent. Lordship.
2023 onwards. You were on bail earlier.
Yes, your Lordship.
Thereafter, what happened?
After the committal of the case before the Court of Sessions, on 30th.
Why 135 Electricity Act is committed to the court of?
Because the FIR was made by the APTSL, subdivisional officer of APTSL, because of the area of.
135 is tried to be, is tried in Sessions Court.
Yes,
Electricity Act. Huh? How Electricity Act? Committal, I mean, the ERC case. Session Judge, 135. By what provision it is sessions? Because otherwise it is up to 3 years.
379 is there. Lordship.
379 is to be tried by session. I don't think it is taped. How can it be?
Any
No,
magistrate.
RPC.
Any
Shape is shape. BNS is open again. BNS is not.
magistrate. Any
Any magistrate. And 135 is also up to 3 years, which may extend up to 3 years. As per the schedule. Now it is in BNSS schedule is
3
there
years.
or not? Schedule is there, BNSS. Person up to more than 7 years, it is court of session. For 3 years, magistrate of the first class. 379. Why it is session, Mr. Counsel?
Yes, your Lordship.
Why it is court of sessions? Any idea?
No, your Lordship, I'm also going through that.
Hmm?
I am also looking for it.
Huh?
3 years punishment. but-
Yes.
But committed to the sessions.
Why special judge? Is there any provision in the Electricity Act? Do you have any idea?
I'm also going through.
You have not gone through.
Yes, your Lordship, not properly got through.
Why?
Hmm.
135.
Yes, your Lordship, there is a provision.
Where is that?
Here in my act, there is an explanation. May I read it, your Lordship?
In the Act,
Yeah, in the explanation part, I have it.
explanation part of which section?
Section 135.
135, explanation. Read this.
Use of electricity over and above sanctioned load. There is an explanation. The complaint filed by the complainant, not only the special court can punish the accused if it is established that the accused had committed the offense under section 135 to 139 of the Act.
It cannot be. Okay, 153. 153 is special court, not sessions court. It is not.
It's
So a person shall not be qualified for appointment as a judge of a special court unless he was immediately before such appointment an additional district and session judge. 153(3). That is why. Yes, Miss Begum.
yes, Lordship.
Hmm? Let them appear.
Yes, Lordship.
It will expedite the trial. Whatever. We'll keep this NBW under suspension. They will appear on a particular date. We'll dispose of.
Yes,
Then their prayer will be
yes.
considered.
Yes, Lordship.
Their prayer, they will appear before the court and seek bail, and it will be considered in accordance with
Yes, sir.
law and on merits. Heard.
Mr. Amar Sadiq.
MR
Sodial.
Sodial, Learned Counsel for the two petitioners.
Yes, Your Lordship. Sir Tarapali and Sobahan.
For the petitioners and Miss A. Begum, Learned Additional Public Prosecutor for the respondent state. Post up. Para. This criminal petition under section 582, 52228, comma, Bharatiya Nagorik Purakkha Mahita 2023 is preferred against an order dated 2/8/2023 and subsequent orders passed thereafter by the Court of Learned Session Judge Kamrup Aminggaon in special within bracket electricity case number 2 of 2023. Full stop. By virtue of section 153, comma, the Court of Learned Session Judge Kamrup Aminggaon is designated as the special court. Post of para. The two petitioners were named as accused in a first information report prepared lodged by the sub-divisional engineer, Boko Electrical Division, Assam Power, APDCL, Boko, before the officer in charge, Kuntoli Police,
Outpost.
in charge, Kuntoli Police Outpost, under Boko Police Station, alleging power theft. Full stop. The said affair has been registered as Boko Police Station case number 448/2021 under section 379 IPC read with section 34 IPC and read with 135, Electricity Act 2003. After investigation, the IO submitted a charge sheet by charge sheet number 153 of 2021, finding a privacy case for committing the offenses under section 379 IPC rate with section 34 IPC. Also on submission of the search sheet, the special court to cognize under section 379 IPC rate with section 34 IPC and section 379 stroke 34 IPC rate with section 135 IPC and by an order dated 36/2023, summons were issued. So for Pusto. The United Special Court on 36/2023 allowed a prayer made on behalf of the petitioners as accused for their appearance on 2/8/2023. As the petitioners were already on bail, first of February. The case, special electricity case number 2/2023 was thereafter posted on 2/8/2023 for the appearance of the accused persons, that is the petitioners. Person. As the petitions were found absent on 2/8/2023 without any steps, the special court issued non-bailable warrant of arrest against both the petitions. The case was therefore posted on 3/10/2023, 20/11/2023, 4/1/2024, 22/2024. It will be Yes, 32%, 33%, 34%. And lastly on 3/6/2024. Post up. On all those dates, all these dates, the petitions were found absent on call and the land special court issued NBWS, trace NBWS against the two accused persons. First of some of the NBWS returned with reports. First of the contents of the reports are not specifically mentioned in our first of Mr. Sodiel, Learning Council Board of Petitions has submitted that due to
Paragraph number 7, Your Lordship, page 4. Miscommunication regarding.
certain miscommunications and wrong legal advice. The petitioners did not appear before the Land Special Court from 2/8/2023 onwards. Also, he has clearly submitted that though there was defaults, consistent defaults on the part of the petitioners to stand in the trial, the petitioners earlier, the petitioners intend to take part in the trial to face the charges. Also, Ms. Begum, additional public prosecutor, has stated that notwithstanding has clearly submitted that notwithstanding issuance of NBWS since long, if the petitioners submit to the jurisdiction of the land special court by appearing before by appearing before the court, the same court facilitate an expeditious trial. Full stop. Para. Having gone through the orders, it's passed by the land trial for special court in special electricity case number 2/2023. Since on and from 36/2023 onwards, it is noticed that the NBWs were returned with report there was non-appearance on the part of the two accused persons who were the petitioners here. Full stop. As a result of their non-appearance, the trial has got protracted. Full stop. In the event, the petitioners appear before the land special court at an early date to face the trial, the same would facilitate an expeditious trial. Full stop. For the aforesaid reasons and taking into consideration of an expeditious trial, instead of a protracted trial, I am inclined, in the interest of justice, to suspend the NBWS issued against the petitions on and from 2/8/2023 onwards, subject to the condition that the petitions will appear before the land special court on
Next date is 22nd, 7.
on
2nd July.
22/7/2025 without fail. Full stop. It is ordered accordingly. Full stop. The petitioner the petitions have undertaken that they would appear before the land special court on 22/7/2025. Full stop. In view of the specific undertaking given by the petition to appear on 22/7/2025 before the land special court, the NBWS issued against the petitions on and from 2/8/2023 shall remain suspended till then. Full stop. On appearance of the petitioners before the special court on 22/7/2025, they would prefer an application for bail. Also, it is observed that in the event such an application for bail is preferred by the petitioners, the land special court will consider the same on its own merits and in accordance with law. With the above observation, the criminal petition is disposed of.
Deeply.
Item 15,
Wait, please, your lordship. No, it's a application for quashing of the proceeding, my lord. Here, my lord, what happened, my lord, the accused,
He is in the political field.
my lord?
This man is in political field.
No, no, no.
Huh?
He's a retired BSNL employee, my lord.
Retired BSNL employee.
Yes, yes, yes.
Sure.
Oh, not that person, not that person also.
Are you sure?
Yes, yes. He's a retired BSNL person, my retired person, my lord.
Where have you stated? Any idea?
No, no, I've got, yes, yes, so that is apparent from the order, Lordship. I'll show, my lord, because the case was pending, my lord, case 24, my lord.
24.
Yes. Since he retired, my lord, there was no progress, my lord, so he himself filed this
Was
application.
an employee. Petitioner is an employee of BSNL.
Yes, ma'am.
But you are saying 53 years.
My lord, yes, my lord, that is some
Huh?
mistake is there. Mistake is there, which is absolutely right. There's a mistake in there. It should be 61, my lord. Should have been 61.
Yes, what is your prayer here?
Here for quashing of the entire proceeding, my lord, here charge sheet has been submitted under 306, my
Who
lord,
is the FIR?
page 17, my lord. He was
Enter
the,
proceeding PRC, this time, 306.
there's a suicide note also, my lord, and
Sarsit. Okay, where is the FIR?
FR page 17, my lord. The person was found, my lord, he committed suicide at the railway track, my lord. And suicide note was found, and he mentioned the name of two persons, my lord, Suresh Bora and Kajal. So Suresh Bora is with your lordship, my lord. This occurrence took place, my lord, 27/7/2016, my lord, and on that day itself, FIR was lost, my lord. He was arrested, released on bail, my lord. And some observation is there. I am not going into that, my lord, in the bail order, my lord. Now, since there was no progress, my lord, he retired in the meantime, my lord. So this application was filed, my lord, page 24.
Due to frustration.
We have annexed the charge sheet also, my lord, and the.
You are the owner of the
Yes.
premise.
I am the landlord, my lord. He was the tenant, and
Huh.
I asked him to vacate the tenanted premises from the last 6 months, as per the, my lord, suicide note itself, my lord, and as well, my lord, the 161 statement of the witnesses we have annexed, my lord. So
Yeah,
there is,
yeah, Sarsit. Okay.
so there is possibly, my lord, that abatement, my lord, 306, my lord, two ingredients.
Seen the report. Procedure submitted. Where is the Sarsit?
Charge sheet also fine. It starts from, my lord, page 30 to 45, no? Page 30. Yes.
Okay. Then
Now, my lord,
proceedings after submission of Sarsit. What is the
our
then
committed.
someone's were issued?
Yes, yes, committed.
Where is it?
He voluntarily appeared, my lord, before the.
Where is it?
my lord.
Phone of Sharma.
That also we have annexed, my lord.
Sarsit. The case is police record, PhD is network. Sarsit to the court of CCDM. Summons issued. Should as well. Inside. When did you appear?
I'm posting that. now. It will be 48, man. Case number 48.
48.
Yes, ma'am. The fourth para, however, accused so and so has voluntarily appeared. So find that. my lord.
Hmm.
Now,
Suicide notice there.
my lord.
Suicide notice
Yes,
next.
yes, yes. Page 54, man.
Base 54.
Yes. Page 55, that first para, that is important because my lord, he states that, my lord, however, in June, he again demanded rupees 30,000 as advance and increased the monthly rent from 1,000 to 2,000. So from June, my lord, and he committed suicide on 27th of July, my lord. So for 1 month, there is no allegation that there was any proximate incident happened, my lord, prior to, immediately prior to his commission of suicide. My lord.
How you have got this suicide note?
Because the copies were served, my lord, 207.
Copies, 207.
Yes.
Yes, he could have resorted to civil suit,
Exactly.
or
Exactly.
seek injunction
That's also.
not to evict.
Right.
Not any bad of rules and all.
No physical harm.
Art, Mr. A. Chaudhary. Learned counsel for the petition. Miss A. Begum. Learned additional public prosecutor for the response state. Poster. Respondent number 2 as the informant had lodged the first information report before the in charge Itasali Police Outpost on 27/7/2016, stating interiorly that his brother, Sarat Sharma committed suicide at railway tracks and leaving a suicide note behind in his house. Poster. The informant alleged that in the suicide note, the disease named 2 persons, including the petitioner. Poster. Accordingly, the seat FIR was registered as Nagaon Honda Police Station, case number 1875/2016, under sections 306/34 IPC. So after investigation, the a charge sheet was laid on 39/2023, finding a privacy case against 2 accused persons, including the petitioner. Poster. On submission of the charge sheet, the Court of Planet Judicial Magistrate Naga took cognizance of the offences under section 306/34 IPC against both the asserted accused persons, post of the petitioner, who had been extended the benefit of bail in the meantime, appeared before the trial court on 21/5/2025. And he was about to go on bail post of by instant criminal petition under section 4/5/28 BNSS is preferred seeking passing of the FIR dated so and so. Passing the FIR number for it. FIR lodged in connection with Noga Honda Police Station, case number 1875/2016, and the search is submitted thereafter on 39/2024, and for staying further proceedings of PRC case number 169/2025, presently pending before the court of Learned.
In fact, it has been, sorry, but it has been some.
Chief Judicial Magistrate, Court of Learned, Chief Judicial Magistrate. Nagaon. Post of Para. Issue notice returnable in 4 weeks. As well, so as appeared, accepted. Post of. Third, then counsel for the parties, the came fair. Post of. A petitioner has annexed a copy of the suicide note, allegedly left behind at the deceased, and which was furnished with the petition at the stage of 207 CRS. In the suicide note, the deceased had entirely stated that the petition as a landlord of the deceased had harassed the deceased either by insisting advance consideration or by increasing the monthly rental in connection with the shop wherein the disease was a tenant. Having regard to the actual, having regard to the contents of the, having regard to the allegations privacy contained in the suicide and the ingredients of the offense required to affect the offense under section 306 34 and reinforce the submissions of and counsel for the petitions. First of all, it is ordered in the interim that further proceedings of PRC case number Case 60.
Wow. Case number 169 of 2025.
Where is that? What does it?
Right. First step.
PRC case number 169/2025, presently pending before the Court of Chief Judicial Magistrate, Nogam, shall remain suspended till the returnable.
My lord, can I make a small prayer? What happened in the meantime, it has been committed, my lord, but no dates has been given before the sessions court, my lord, session. So that I'm just pressing.
Further proceedings
Yes.
of the case against the petitioner, which has arisen out of PRC case number.
My lord. Highly agree.
May I please, Your Lordship? Lordship, petitioner before your Lordship is the government servant presently posted at Lakhimpur Medical College.
Government.
Servant. Presently
Hmm.
posted at Lakhimpur Medical College Hospital.
Stars it. Let us see the FIR.
Final FIR it is 21 minus. type copy of pen.
Abetment will be
Long a pen.
what is your name?
Tamil.
What I just can't keep it going. Venus, no? Yes.
My lord, in this case, FIR was lost even before my proposed marriage get married. Proposed marriage was a 5/4/25, my lord, and FIR was lost 25/3/25, my lord.
Oh. Yes. Because cause of action arose before that. Privacy ingredients of the offense of old 415 is there. Old 415, nowadays 318. Privacy is there. Crossing is possible only if the ingredients of the offense is not available. Privacy is there. No question of crossing.
For time being proceeding will be with an election.
When there is no privacy case for you, and there is a privacy case, that the ingredients of the offense under section 318 are made out on a reading of the FIR. The case is privacy against you.
Section 69.
That is why old 415, new 318 is privacy made out. No, I don't find any. You feel the trap. I close it. Ingredients of the offense are available in the FIR. Whatever is there.
The time comes up to page number 36, my lord. The side sheet, the fourth paragraph.
I have read everything already.
You put tattoo in her body, my lord. The mayor was cancelled.
It is a matter of proof ultimately.
With all respect, my lord, I want to place one judgment of the Supreme Court, my lord.
You place how many judgments you want. Right from Bhajalal, R.P. Kapoor, 1968 to 2025.
Come to pair 9, my lord. May I read mine? In our considered view, this is also not a case where there was a false promise to marriage to begin with. A consensual relationship turning source or partners becoming recent cannot be a ground for invoking criminal.
Read. Read.
And such conduct not only pardon the court, but blot the identity of an individual accused of such heinous offense. This court has time and again warned against the misuse of the provision in has time it is fully to treat its breach of promise to marry as a false promise and proceed with a part of offense under his offense guidelines.
Yes, Mr. Coach. Because here every case is to be decided on its own facts. Everybody came, that is what they say, then proposed date is fixed. In the gap, this relationship, then marriage was broken. Relation physical. That is, the ingredients are there, at least for 415, old 415, new 318. That cannot be quashed. This may not sustain. And what is the stage now?
Experience, ma'am.
Cognizance taken. Yes. The trial had
HML. HML.
HML, learned counsel. MHLE or HML?
HM.
HM. Learned counsel for application and Mr. Learned litigation public prosecutor for respondent number one from state of the sun. Para. This criminal petition under section 528 BNSS has been filed to SC to quash, seeking quashing of the first information report registered as Dunduma Police Station, case number 52/2020. And a charge sheet dated. Charge number 61/2023. Filed in connection with Dunduma Police Station, case number 52/2025, and an order taking order dated 27/5/2025. Passed in PRC case number 280 of 2025 by the Court of Judicial Magistrate First Class, Tinsukia, first of the FIR was lodged by the respondent number 2 as the informant before the officer in charge, Dunduma Police Station on 25/3/2025. Post of. After completing investigation, the charge sheet was submitted by the IO, finding a biopsy case against the petition for committing an offense, for committing offenses under section 318 within bracket 4/69/351 within bracket 2, BNSS. Full stop. After perusal of the materials available in the case records of PRC case number 280/2025, Commander Leonard Trial Court took cognizance of the offences under section 318 within bracket 4/69/351 within bracket 2 of the BNS proactive against the petition as a solicited against person and issued by the order dated 27/5/2025 and issued summons to him for his appearance to stand in the trial. Post in the above I drop the incident criminal petition is withdrawn. Post counsel for the petitioner has contended that the ingredients of the offense just mentioned in the FIR charge sheet and the charge sheet are not made out. Post of. He has also referred to a submission, referred to a decision of the Supreme Court in Amol Bhagwan Nehul versus State of Maharashtra, reported in 2025, SCC Online SC 1230. Post of, in support of his submissions. Post of. The contents of the affair and have been reduced. Post of the manner in which the investigation was carried out thereafter are reflected in the charge sheet. Post of the allegations, in substance, are to the effect that initially, the families of the petition and the respondent number 2 by visiting. Had arranged the marriage between the petitioner and the respondent were two. Full stop. Thereafter, comma, after deciding a date of marriage, comma, applications were submitted before the jurisdiction marriage officer for solemnization of the marriage on a fixed date by submitting applications. By submitting the necessary application, first step. In the interim, comma, the petitioner taking pretext of the marriage scheduled on a fixed date, comma, had established physical relationship with the petitioner. Respond number two. Also, but subsequently, comma, he did not solemnize the marriage on the date fixed for registration of the marriage. Question. Having regard to the nature of litigation, comma, made in the comma, it privacy appears that intelligence of the offense under section 318 BNS and section 69 BNS are found to be present of privacy. For some in such we have the decision in Amol Bhagwan Nehul. Supra is with regard to a consensual relationship turning so or partners becoming distant. Postal. The parties therein became acquainted first, and thereafter, comma, a friendship developed between them, followed by frequent interaction. Also, on the contrary, comma, in the case in hand, comma, the marriage between the petitioner and respondent number two was supposed to be solemnized after arrangement between both the families and in the interim, the petitioner on the pretext of the marriage to be solemnized in the future on a future date, comma, had established physical relationship with the respondent number two. So, in view of such allegations and comma, the case decision in so and so is of no assistance to the cause of the petition. First of having found no privacy, having found no merit in the instant criminal petition, comma, instant criminal petition is dismissed.
1987.
May I please, your lordship? Both petitions are same lordship, only petitioners are here, lordship, different people. Lordship, what happens? The fact of the case is that a headmaster of a school against whom several types of financial or other illicit relationship allegations were in public domain since
What are the offenses?
2-3 years, Lordship, may I submit?
108. What is 108?
Suicide, Lordship.
Abetment or what?
Abetment.
306, equivalent to 306.
Lordship, what happened? Against these headmasters, several types of allegations were there in public domain since last 2-3 years. And the petitioners being public vigilant persons or and reputed persons, some persons organize a public meeting to take to discuss regarding the headmaster's his works, ex Lordship.
Okay, come to
And-
page 79.
Yes, Lordship.
This is a Sarsi.
Yes, Lordship. Thereafter, Lordship, after that meeting, he committed suicide. And now, Lordship, FIR has been filed alleging that due to this public meeting, by this public meeting, he is mentally harassed and thereby he has committed suicide. Lordship. Initially, 18 persons are named in the FIR. After investigation, 9 persons total who were government servant. 9 persons were seated, Lordship. And here, Lordship, 4 persons are in
When
anticipation
that man died?
on 28th of December 2024. Meeting
20?
28th of December
Yes.
2024. Sorry, Lordship, 27th. On 28th FIR file,
27 December 2024.
24.
Suicide?
Suicide.
Okay. And where is the FIR?
FIR file on the next day, 28th of December.
Where is that?
Page,
FIR.
page number is at Lordship 58. 58 in Bharnegul.
Okay, Varnekura, let us leave on the Varnekura.
Bharnegul. 58, page number. Here, Lordship will find one name, Mr. Jugesh Borua Dhankon, Mool Abhijukta, within bracket. He is identified in this FIR as Mool Abhijukta, who is stand in item number item number 19, petitioner number 1. In item number 19, petitioner number 1 is Mr. Jugesh Borua. And Lordship, his father has established that school. Jugesh Borua's father initially established that school and he was the founder principal of that school. After that, this person came and now Jugesh Borua's words are also
Any
student.
suicide note?
No, Lordship, there is no suicide note.
No suicide.
No suicide note. And Lordship, I have annexed several types of
Art.
documents here, Lordship.
Mr. G. Somwa. Yes.
Otherwise, it's going by FIR and traffic.
Ah.
There was continuous harassment to that person. That continuous.
Now, what is the present stage? What is the present stage?
Yes, Lordship,
Ah.
present stage is they
Sarsi submitted.
Sarsi submitted, summon issued. We have received summon, Lordship. And Lordship, on 14th of July, next date is coming. So Lordship, stay may kindly be granted. Lordship.
Stay.
Yes, Lordship.
Against how many persons? Sarsi?
Sirs, 18 persons were named in the FIR. 9 persons were seated. 7 were firstly seated. But Lordship, what happened? Prosecution sanction was not there against 2. And now,
Oh,
they-
this is not a, Mr. Don't extend to sanction for this kind of offense.
as per the search sheet, it is written in the search sheet.
Not required. Court will not go by IO's advice. And don't make such submission also. Heard Mr. G. Somwa. So by this two petition, all of them have come or what?
No, Lordship. One.
How many left?
Uh,
One.
No, Lordship, two left, one came earlier and this order is passed. One came earlier, this order is passed.
Success or failure?
No, Lordship. One day, only 1 day stay is given. 1 day stay.
Huh?
Only 1 day stay is given. Lordship.
Then, sir, what to do?
Lordship, make.
I have to follow the coordinate bench judgment also, observation.
Otherwise, to see the kind of, yeah, FIR and something. In 2023, because if they had any grievances regarding disapprobation of this thing, they could have approached the police. They not only kind of blackmail him, they.
Lordship, I have annexed all documents, they
Mr.
communicated,
Samoa,
they communicated.
no, but this man came before you,
Yes.
came earlier. Got an order,
Yes,
a coordinate bench.
yes, Lordship.
We have to respect the coordinate
Yes.
bench's order.
Yes, Lordship.
So we'll fix all the dates on 14/7.
Yes, Lordship.
And same order will pass.
Same order will be on 14th, 1 day stay may be granted.
Huh?
1 day stay may be
Good,
granted.
what 1 day of stay? Where is that?
Point number 9, Lordship.
No stay.
No, Lordship, point number 8. Meanwhile, the petitioner may
Pray for adjournment. That is not. So you miss the bus. I have to respect the coordinate bench's order also.
Obliged.
Otherwise, I started dictating the order. Heard Mr. G. Somo. Learned counsel for the petitioners. Very order, same. And Mr. R.R. Kosik Learned. Additional public prosecutor for the respondent number 1, State of Assam. Post of the instant criminal petition under section 528 CRBNSS is preferred, seeking setting aside of the criminal proceedings in PRC case number 47/2025, presently pending before a court of managed judicial magistrate first class Dhokwa. Post of PRC case number 47/2025 arose out of Dhokwa police station case number 114/2024. Post of after registration of the FIR lodged on 28/2/2024 for the offenses under section 108/3 within bracket 5, B and S. The charge sheet was also laid thereafter, finding a forensic case against 7 number of accused persons under section 108/3 within bracket 5 BNS. Post of the FIR was lodged against 17 persons as accused, including the petitioner's hearing. Post of para. It is submitted by Mr. Samoa Leonard, counsel for the petitioners, that one of the charge sheeted accused person, Navonita Kugul, has earlier approached this court by criminal petition 666/2025 and coordinate advance while issuing notice to the respondents, has posted the case on 14/7/2025. Was the para. Mr. When is the next date?
next date is same, 14/7. In trial court also, in high court. also.
14/7.
Yes, Lord.
Okay. Issue notice returnable on 14/7/2025. As Mr. Kosin, as the peer accepted. Correspondent number 1. The petitioners take steps for service of notice of harassment number 2 by registered post TD within 2 working days from today.
Only 2 days.
You take steps?
Today itself.
Wait, tomorrow?
Tomorrow.
The prayer for interim leave will be, sorry, the scan copies of the trial court reports have already been called for
In
in connection with criminal petition number 666/2025. And it was observed in the order dated 11/6/2025 to the effect that the said petitions prayer for interim stay would be considered on receipt of the scanned copies of the TCR along with the scanned copies of the case diary. Scanned copies of the TCR and I got a very call for. Correct. The prayer for interim relief in case of the present petitions would also be considered on the returnable date. At least the case on 14/7.
Along with
Same.
this 666.
Along with 666.
Criminal
Same
petition number.
in item number 8. Item number 8.
Item number, no, Lord, 7 and 19.
7 and 19.
Deeply obliged. Lord.
May it
Yes.
please your lordship. Lordship, this petition had come up yesterday before the
I-
honorable court as well. Lordship, subsequently, on advice, my lord, I have the instruction that to implead the informant or something.
Hi, Mr. D.K. Boito, I land counsel for the applicant petitioner and Mr. R.R. Kosik, learned counsel, learned additional public prosecutor for the opposite party. That's respondent number 1, state of Assam, Mr. The instant application. This interrogatory application is preferred seeking impleadment of the informant.
Abetment.
Who informant of informant on the informant who instituted the complaint case who instituted the complaint, complaint case number 652/2024 before the court of Chief Judicial Magistrate and Chief Judicial Magistrate Morikam, alleging commission of offences under sections 417, 420, 34, Indian Penal Code against the petitioners, applicants' petitions. The said complaint was subsequently registered
Yes, my lord, this was
as
registered Morigao PS case, my lord.
Morigao. Morigao Police Station case number.
12, my lord.
Where is that?
Lordship would find that at page number 59 of the criminal petition.
59. As Morigao Police Station case number 12
12 of
stroke
2020.
2025. Under sections 406 IPC and 420 IPC. Post on. The particulars of the opposite party, this informant, said opposite, said informant is mentioned in the cause title. First one. The opposite party as informants has been sought to be implemented as a respondent number 2 in the accompanying criminal petition, which has been preferred under section 528 BNSS, seeking passing of the FIR lodged by the said informant. In view of the statements and amendments made in this interlocutory application to the above effect, the instant interlocutory application is allowed to stop Mr. Whittle and counsel for the applicants petitioners shall file an amended cost title in terms of the so motivation by tomorrow. Full stop. Okay.
My lord,
Yes.
my lord, may we come to the criminal petition? My lord, it's a quashing application and now the informant is a party. Lordship would direct the issuance of notice. Lordship, however, on 3 points of my lord irregularity and illegality.
What is the FIR?
FIR, Lordship, would find at page number 59, that is the format
59.
59, my lord. Because this is subsequent to 156. These are the format pages, my lord.
Your
initially
name
complained.
is
My name appears at page number
Hiren
62.
Setia,
no?
SBF agency.
Yes, ma'am.
59.
59 is the FIR format
The
page.
format.
Format.
Allegations.
Allegations 420, 406, my
No,
lord.
no.
Basically,
This is the complaint.
this is the complaint, my lord,
Ah,
to the magistrate, and the
Yes.
magistrate by the mechanical order.
this has been treated as a FIR
This has been
in view of
treated as an FIR.
156.3.
156.3, my lord.
Okay. What is the nature of the allegations?
Nature of the allegation is that, my lord, to summarize the same, the my lord, in the FIR, the accused number 1, Kirloskar Oil Engines Limited, they make harvesting machineries, my lord. Accused number 2 is the representative of the Kirloskar. Office number 3 is my proprietorship concern, my lord.
Okay. You are a dealer or what?
I'm a dealer. I'm a
Okay.
dealer. I deal with Mahindra Kirloskar harvesting equipment. Number 4 is my branch manager. He no longer, my lord, the post also doesn't exist. The gentleman has left, my lord. And number
It is a
5
proprietorship.
proprietorship.
Okay.
My lord, my GST proprietorship registration document is also part of it.
Then allegation.
Lordship, the allegation is that the informant had come to my dealership. He came looking for a harvesting equipment. He happened to choose an equipment by the name of Kirloskar Harvester PT1205. After harvesting, after Lordship making up his mind that he would purchase it, he made due payments of 7,50,000. That is not disputed, my lord. He had paid it to me. 7,50,000 and took delivery of the equipment. Delivery after some days, my lord, he had this grievance that the equipment was not functioning properly. It was malfunctioning. It was malfunctioning, and accordingly, my lord, he informed me. He informed the manufacturing company as well. Technical officer had gone, visited his place, but he was not allowed to have a look. By that time, the informant has already made up his mind that he wants a complete refund and additional amount of rupees 1 lakh from whoever pays, my lord, be it Kirloskar, be it myself. As such, my lord, this being his grievance, my lord, repair was not allowed, and he had instituted a consumer complaint, my lord, on 11/7/24.
Which one is earlier?
My lord, the consumer complaint is earlier.
Is earlier.
Is earlier, my lord. From my knowledge, my lord, the consumer complaint was filed on 11/7/24. I'm going by the date of the affidavit, my lord, date of filing. 11/7/24, and the FIR was lodged on, rather the complaint petition was lodged on 30/7/24, my lord. The consumer complaint is at.
What is page 78? I have brought to 78 page, 12/7 it is mentioned.
78, my lord. Yes, my lord. This is one of the annexures which has been provided to me when I took a certified copy of the FIR. This allegedly, my lord, on the part of the informant, even though, as per the guidelines of Priyanka Srivastava in this complaint petition's affidavit, there is no avertment that he has resorted to 154(1), that is, he has gone to the OC of the police, Morigaon police station, or to the SP, my lord, in the affidavit. However, my lord, in his complaint petition body at page number 70, at para number 10, my lord, he has made an avertment that the complainant has filed an azahar at the office of the superintendent of police on last 12/7/24
Yes,
regarding
Mr.
the
Kaushik.
incident subject matter.
Consumer courts.
And my lord,
151, 114.
Huh?
yes, my lord, because the requirement is twinfold in Priyanka Srivastava. 154(1) and 154(3) both are mandatory, my lord. Even if we go, even if not affidavit, I'll concede, my lord.
151 is of BNS.
No, my lord, of the CRPC.
154.
154(1) FIR to the
Yes,
officer in charge.
154. I heard 151. That is why.
Lordship, I apologize, my lord.
154(1), 154(3).
154(3).
Oh.
Though not in affidavit, I'll concede that he might have considered to, my lord, this thing.
So
And lordship,
whether it has resulted into search it.
no, my lord, but the registration of the FIR itself is, my lord, the abuse of process of law, my lord, as per my limited understanding of 415 goes, my lord.
Right.
And my lord, I'll draw your lordship.
No,
attention to
what
one
would
thing.
be the interim order?
Lordship, stay of the FIR. my lord.
Not giving that complaint. Format.
Well, here, but he has filed consumer complaint
And my lord,
and deficiency in service, basically. He paid the money. Machinery was delivered. Machinery was delivered and it malfunctioned or whatever. Maybe defective, maybe so and so. But machinery is delivered. It was not working properly. So it is a case of deficiency of service or whatever, but not criminal proceeding.
and lordship, in the FIR also, he has prayed for refund, my lord, at page 71.
Okay, heard, Mr. D.K. Boito, Learned Counsel Board of Petition. R.R. Kaushik, Learned Tradition, Public Prosecutor for the response number 1, state person. First of the informant. So, no, again, the instant criminal petition under section 528 BNS. It takes time for me. BNSS
Double S.
is preferred, setting aside of a first information report dated 28/8/2021, which has been, it was lodged in 2021.
No, my lord, at the index page, it is.
No, prayer, I go by prayer.
My lord,
I don't
my lord, it
remember
was
this.
initiated on 30/7/24, my lord.
No, you come to your prayer, sir.
Lordship, date is erroneous. Lordship. We may be allowed to correct.
We generally go to the cause title or to the prayer. We don't go into the
Here, my lord, it was mistaken.
first information report, which has been registered as Morigaon Police Station case number 12/2025 under section 420 IPC. All are wrong. When 2025, how it can be 420 IPC and section 406 IPC. Those things. The informant is directed to be informant of Morigaon Police Station, case number 12/2025 is ordered to be, has been ordered to be implemented as respondent number 2 in the instant criminal petition by order passed today in I criminal number 703/2025. Full stop. Para. The gist of the allegations in the affair is to the effect that the informant purchased a crop harvesting machine when
Lordship, on 23rd of May 2024.
huh,
23rd of May
From-
2024.
Messrs. HVF Agency, 80 Road, Guwahati, where within bracket the petition number two,
As an office.
where the petition number right, where now, in which the petition number one is the sole proprietor. First of, the informant paid a sum of rupees 7,75,000 towards sale consideration of the crop harvesting machine. First of, after purchase, the machinery was delivered to the informant. Post of, the affair was lost, alleging that the crop harvesting machine started malfunctioning and there were defects which had caused the informant losses in various forms. Also, Mr. Boydell and counterpart of petition has submitted that prior to institution of the FIR stroke complaint, submitted that the informant had initially submitted a complaint before the Court of Learned Chief Judicial Magistrate, Morigaon.
Morigaon, man.
Morigaon.
Complaint, consumer complaint before the Consumer Dispute Redressal Commission, Morigaon.
No. Complaint, it was FIR
Present-
complaint.
Complaint petition, my lord.
Where is
The
that?
FIR complaint, that is at, my lord. Page number 59 is the FIR body, page number 62 is the first page of the complaint.
Submitted. He is from Morigaon.
He is from Morigaon.
Instituted complaint, complaint case number 652/2024 before the Court of Learned Chief Judicial Magistrate, Morigaon, which has been later on registered as Morigaon Police Station, case number
12 of 2020.
25 after the Learned Court directed the complaint to be registered as an FIR under section 156(3) CRPC. He has further submitted that prior to institution of the complaint, there was no compliance of the provisions of section 154 within bracket 1 and section 154 within bracket 3 of the CRPC on the part of the complainant informant. Thus, no cognizance could have been taken on the complaint so instituted. He has further submitted that prior to the registration of the FIR, the informant had already approached the District Consumer Dispute Redressal Forum at Morigaon by filing a complaint, complaint petition number 5/2024, alleging deficiency of service and seeking compensation. In the affair also, the informant has sought relief in the form of compensation or refund of the
My lord. refunding
still
of the-
consideration paid by him for purchasing the crop harvesting machine. Issue notice returnable in courts as so and so has appeared accepted. One corresponding government notice should dispense with. The petition shall take state for service of notice upon the respond number 2 as informed by registered proceeding within 3 working days from today. Those are having regard to the projections made on behalf of the petitioner and having regard to the ingredients required to be fulfilled for the offences under section 420 IPC and 406 IPC and institution of a complaint case before the district consumer redressal forum, Morigaon, at an earlier point of time, it is ordered, in the interim, further proceedings in connection with Morigaon Police Station case number so and so shall remain state suspended state till the return of the date.
Deeply approved.
Case diary.
Case diary. Okay, scan copies of the case diary.
Obliged.
Matter of declare further consideration will be given. Issue notice, let's just scan copies. Yes.
Number 21.
What has happened to Saddam Hussein?
Saddam Hussein is a registered owner of a motor
Huh?
vehicle. Saddam Hussein is a registered owner of a motor vehicle, Your Lordship.
Registered?
Owner,
Huh? Owner of a motor vehicle?
Your Lordship.
Yes.
That was taken by police without,
Taking an issue, will issue notice then. Custody.
actually, no FIR was registered.
Custody, you want custody?
Yes.
Let them get a report. Heard Miss A. Begum,
Able.
Learned Counsel for the petition and Mr. R. Kosik, Learned Additional Public Prosecutor for the response number 1 and 2. Kosik. You approach the trial court?
No, my lord.
Huh?
No, my lord.
Why don't you go to the Supreme Court and directly? Huh? I thought that you approached the trial court.
Actually, my younger brother was searched by the police at my home, but he was not found.
Whatever,
Then he filed a bill.
without approaching the trial court, seeking custody of the vehicle.
No case was registered against any, no case was registered against the vehicle or my.
Yeah.
No FIR was there, no CIDR was there.
You find out, Miss. Will not issue notice. Bail was granted on a report from Juria Police Station. You see the annexer, page 11,
Space.
by this court in an anticipatory bail application. Same petitioner. Oh, not the same petitioner.
His younger brother, Your Lordship.
Huh?
Saddam Hussein's younger brother is Mehdi Alam, who was searched by police at his home. He
So Saddam is,
my motorcycle was kept taken away by the police from my house.
Saddam is not an accused.
No, my brother is also not.
You are
accused.
free to go to the police station.
Yes, Your Lordship.
Then why
It was not given.
Why
to
you
me, Your
don't
Lordship.
make an application before the magistrate?
Your Lordship, I requested the police officer.
Don't invoke the jurisdiction of this court.
Secure themselves.
No. Secure the ends of justice, whether the jurisdictional magistrate is not competent. Huh? Jurisdictional district judge is not competent. Then why secure the ends of justice Then to secure the absence of justice, I think you better approach the Supreme Court then. You are overreaching the jurisdiction of Magistrates Court, District Session Judge Court, then you can overreach the jurisdiction of this court also. At the drop of a hat, I'm not entertaining. You are not an accused. You can simply say that before the magistrate. Call for a report.
Inherent power, your lordship.
But power may be available. Power is to be exercised in an appropriate case. Not on the drop of a hat. I'm not entering, I'm dismissing. Or other, I will impose cost also. If I dismiss. Hard.
My lord, I'm doing it.
You first approach. We'll observe you first approach, then if you come, we'll entertain. But without approaching the magistrate court, no. Pardon, Mr. Begum Leonard, additional public prosecutor for the petition, sorry. Also for the petition, Mr. R. Kosit Leonard, additional public prosecutor for the Harassment state. Ms. Begum has submitted that the petitioner wants to withdraw the petition in order to approach the jurisdictional court first, seeking custody of the subject vehicle. In view of the above submission made by Attorney Counsel for the petitioner, the instant criminal petition is dismissed on withdrawal. First of the petitioner is at liberty to approach the jurisdictional court first.
I think better. I don't know what to.
In number two,
Where is your lordship?
you were supposed to get one.
Huh.
They were to conduct the report, my lord, and I got the show today.
Mr. Consul will put it after vehicle, after vehicle.
Sasi have already been submitted, madam.
Will not exercise today. Heard, Mr.
RB Guhai, madam.
R.B. Guhain, Land Council for the petition, and Mr. R.R. Kosi, Land additional public prosecutor for the responding state. Post of Mr. Kosi has submitted that the report called for by the order dated 12/6/2025 has not yet been received by him. He has thus sought for listing the case on another date post of as sought for and as agreed to by the Land Council for the parties, list the case on. Yes. 15. Not 15. 15 is Thursday. On another normal day. 8. Well, no, these are okay, 18.
Well, Monday.
18. Friday.
May it please your lordship. Lordship, first of all, my apologies, I could not appear on the earlier call. Lordship, this application is filed under section 528. I'm seeking quashment of the impugned order dated 6/6/2025, whereby my discharge application under section 262 of the BNSS was rejected and charges under section 325, 506 and 34 of the Indian Penal Code was framed. Lordship, the FIR, the FIR, your lordship will find it starts from page 30.
Paying for discharge on the ground allegation in our
Lordship, the FIR, it's a family feud, lordship, that has been blown out of proportions. The FIR states that the son of the,
What is the affair?
the FIR, your lordship will find the translated type copy is at page 32. And the original, it is in Hindi, it is in page 33. If I may just.
Sanjay Mahato. Yes.
Yes, the basic allegation is that
Suffering from seizure. He is virtual house of their house. Whose house?
this my house, lordship.
Huh?
My house, our house is in the same compound, Lordship.
False in my house,
Yeah.
whether my child gets very scared. And I informed the household of the scene, he insulted me very, I was attacked from behind by Rajkumari TV. People in a street assault my teacher. Who are the petitioners?
The petitioners are Lordship Rajiv Mahato and Deepak Mahato. Rajkumari Devi is their mother. She has not been charge sheeted by the IO, Lordship.
Okay.
So, Lordship, the FIR, certain allegations are made that we have assaulted the informant and.
So
this-
FIR is not liable to be quashed.
No, I'm not seeking quashing of the FIR. I'll show that the allegations made in the FIR are exaggerated and not supported by the other documents. Lordship is aware, like when we pray for a discharge, the documents relied by the prosecution are to be seen by the learned trial court. No other documents are.
Yes, what is the,
The
what,
Lordship
where you want to
up
show?
161 statements, Lordship. 161 statements. The first 161 statement is the of the opposite party number 2. He has reiterated the same thing. The second, page 38, the Lordship may come for a moment. This is the statement of one of the witnesses. He is one of the purported eyewitnesses, Lordship, Nandan Sharma. Page 38, Annexure 2 series of my petition, Lordship. So this witness states that the informant allegedly started the fight. Thereafter, a scuffle broke out. None of the another 2 witnesses are there who have been examined in 161, Shanti Devi and Hira Kumar. Nobody has corroborated the fact of the injuries that has been narrated in the FIR. Why I'm sure.
Whether this informant was medically
Yes,
examined
yes,
or
I
not.
have annexed that report also, Lordship.
First show me that.
Yes, Lordship may come to the medical report that is on Annexure 3, page 45. Incident happened on 25/10/2022. Medical was done on 19.
No, informant. Who is
Yes,
the
yes.
informant?
Informant is
What is the name?
Sanjay Mahato, Lordship.
Sanjay
Mahato. Opposite party.
Mahato.
The medical report, your Lordship.
Sanjay Mahato.
Yes,
Okay.
the medical
report.
45. Page number 45, Annexure 3. The first is the type copy. Lordship may come to the original copy, 46. That I got under compliance of section 207, Lordship. The incident happened on 25/10/2022. Medical was done on 19/1/2023. Medical was done after a period of about 3 months, 19/1/2023. Down below near the doctor, the signature, the date is given, Lord.
Oh, that may be the date when the report is given.
But still, Lordship, the medical, the injury that is stated in the report, Lordship, it says laceration of the eyes and disruption of the lower vision. Lordship, totally contrary to what has been stated in the FIR. And the Lordship, though it is stated grievous, grievous, but this laceration and bite mark or whatever disruption is there, 320 Lordship, 8 grievous as hurts are mentioned. None of it comes under those eight propositions as mentioned under section 320 IPC. And Lordship, why I was Lordship showing your Lordship the 161 statements, because when your Lordship peruses the 161 statement, 2 views comes out, Lordship. One view might give rise to a mere suspicion, but there is no grave suspicion, Lordship. And in that case, the Supreme Court.
What is your discharge application? It was the informant who initially assaulted the accused person, started the fight.
Yes.
It is your discharge application.
Yes, I have annexed the discharge application also, Lordship. Charge sheet, there is nothing about the injuries, no mention about the injuries, no mention about.
No, who is the charge sheet?
Charge sheet, Lordship will find that Annexure 4. The type copy is at page 53.
What are the annexes?
The charge sheet.
Annex there with?
Yes, charge sheet.
One copy of medical report and one copy of bail bond. So one copy of medical report is there.
Yeah, that medical report we have.
Huh.
Yes.
So injury is available.
Injury, but those are not grievous, as Lordship. 320, if I may take your Lordship to 320. Laceration, bite mark or disruption are not mentioned under 320. And the Supreme Court is very categorical. I have a judgment also. Until and unless the injuries mentioned come under the 8 categories of section 320 IPC, grievous hurt, a person cannot be tried for an offense of grievous hurt. And the 161 statement also, the evidence, the eyewitnesses have stated, some have stated they have not seen any fight. One has stated the informant has come and attacked us. Then there was a scuffle that happened between us.
Now, medical officer
Yes,
has made an observation, injury is grievous.
yes, that is, yes.
So this is a matter of appreciation of evidence.
Yes, but what Lordship says, he says that his teeth was broken, his spinal cord was broken
Teeth was
in the FIR. It is saying, मेरा दांत तोड़ दिया, मेरा रीढ़ का हड्डी तोड़ दिया. Those are totally
Okay.
exaggerated. No, any assault took place, Lordship. A heated argument took place. Thereafter, it was like a blown out of proportion.
how the medical officer, he has submitted a report.
Yes.
Right?
Yes, Lord.
This injury is grievous.
Yes.
We didn't, and he is in the capacity of medical and health officer
Yes.
in FRU, Thirenpara.
Yes. Yes.
So
First of all.
he is presumed to have the basic knowledge,
Yes.
right?
Yes.
On the basis of this report,
Yes.
how can we presume that 320, all these are going into the deeper into the merits?
And why Lordship? When we pray for discharge under 262, then the entire documents that the prosecution relies on, the judgment Supreme Court said that Lordship can go through. The scope becomes a bit wider.
We can
But
examine on the returnable, that not on the privacy.
Yes, Lordship, because the next date is on August 29. Let notice go.
We'll issue
And
notice.
my interim prayer may be considered on the next date after the scan copies are called for from the learned trial court. That will also
But
suffice.
at best, that can be done,
Yes.
not beyond that. Heard, Mr.
Lordship, just before one thing, why I was saying that the medical was done on 19 after 3 months, just one thing I'd like to point out. The charge sheet,
No, on the basis of these documents, we will not reach a conclusion.
no, why I'm saying is just, the Lordship comes for a moment to page 50. No investigation was done for 3 months, which becomes evident because we were arrested on 5/2/2023. After the medical report came, page 50, Deepak Mahanto's details are given. 16 and 17. The same date we were arrested, same date we were released on bail by the police bail. So for 3 months, no investigation was done. The FIR was lodged on 26/10/2022, Lordship. That is why I am saying there was no medical also done, as per my knowledge. Medical was done after a period of 3 months.
Let us have the.
Yes, I just pointed out, Lordship.
Heard, Mr. M. B. Chaudhary, learned counsel for the petitioners. And Mr. R. Constituent additional public prosecutor for the responding of 1, the criminal petition under section 528 B and SS is preferred. Seeking, setting aside and quashing of
Page 64, the impugned order, 6/6/2025. The entire proceedings also I have challenged, Lordship.
the criminal proceedings pertaining to PSC case number 2550 2023 corresponding to GR case number 680 2022 presently pending before the Court of Land and Judicial Magistrate First Class number 4 Kamrup Metro Guwahati. Post having heard the land counsel for the parties, it transfers that matter would require further consideration. Issue notice returnable in polls. As Mr. Kosik has appeared accepted. Petitions of comment with this dispensation. The petitioner shall take steps for service of notice on the response number 2 by Discharge post 2080 within 2 working days from today. Parallel issue notice of episode. The land edition public prosecution. Oh, what is it is already substituted.
Charge sheet alone, charges have also been fixed.
Oh. Okay. The petitioners have also challenged the order dated
6/6/25, page 64.
6/6/2025, whereby the petitioner's application for discharge was rejected, has been rejected. By the Land Trial Court. First of the Land Trial Court has proceeded to frame charges against the petitions under section 325/506, IPC, read with section 34 IPC. And the case is at the stage of evidence. Scan copies of the case record of PRC case number so and so be requisitioned. The prayer for interim relief will be considered on the return evidence.
Lordship will fix a date.
No.
After 4 weeks, highly opposed.
May I please, your lordship? Lordship, in continuation of yesterday's deliberation regarding section 148 of NI Act, lordship, that may and shall, lordship. Lordship, I have come across Lordship, I have come across two judgments of the Honorable Apex Court, lordship, where it has been held, it has been observed that this may and shall, in consideration with the intention of the legislature, lordship, in exceptional circumstances, the discretion lies with the Honorable Court. And subject to the facts of the each case, lordship. May I press this?
Please.
Lordship, in Muskan Enterprises, lordship. The relevant para starts from para 24, lordship.
This is an act.
And I, lordship.
Okay.
Earlier, lordship,
Any specific part?
lordship 24, then 28, lordship. Lordship,
One.
it has to be considered with the facts of the each case, lordship.
Which paragraph?
Lordship, in Muskan Enterprises, lordship, para 24, and more specifically in para 26, lordship. May I read, lordship?
I've already read.
Lordship. Earlier, it was mandatory, lordship, when SS Deval versus Virendra Gandhi was governing the field, lordship. After 23, this mandatory nature was diluted, lordship.
So your case is, the compensation was 4 lakhs.
Lordship, the
Fine was 4 lakhs.
no, fine was 4 lakhs. The amount, the bounce amount was 2 lakhs.
2 lakh 10,000.
Later on, it was enhanced to 4 lakhs with
Fine.
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 Now, Lordship, I have been in behind the, my punishment
And
was 6 months.
6 months.
I am already 5 months, 4 days behind the
And fine was with a default clause.
default clause, Lordship.
How
So,
much?
3 months, Lordship.
3 months.
Guys, and I. But that thing cannot.
If- From which date you were in
From Lordship,
custody?
22/1/2025, Lordship. I surrendered
20.
before the Honorable Court.
Where is your statement?
Statement in my pleadings, Lordship.
Obviously.
Lordship, it was not drafted by me, Lordship.
See, mister, I have given you enough time.
But
If
Lordship,
you
it is a
don't give
fact.
the handle, then where is the
Lordship, it is
question?
a fact, Lordship. I cited.
Because see the question, the language, I have to make out a case for
Gotcha.
you, fit, an appropriate case.
Lordship,
Para 27 of the judgment.
Lordship.
I tried to show that much should be
Lordship,
given, right?
Lordship.
To handle that 5 months, it has to be on record. That statement you could not make. That much care should be taken, sir.
Lordship.
It is very difficult on the part. That day, we tried to extend the benefit to that family court. So many oral submissions on black and white, nothing. We could not, despite some handle should be given, sir. That is why I posted, now I am satisfied. But
Lordship.
to make out a case, wow, this is very difficult. You submit, then tomorrow I am giving you time.
Lordship.
Otherwise, somebody showing this order will start taking benefits.
Understand, Lordship.
Not for your case, but for others.
Lordship.
See the coordinate bench. Yes, to make out a case. See the coordinate bench has been extending that.
Lordship. By tomorrow.
We also know the tricks.
Lordship.
Not if possible.
Lordship.
Otherwise, if I have been handed over many orders on the prayer of Dr. P.P. Medhil and the Council Court of Petition, is the case. Our question. Because lady, 5 months, I am thinking of it, 6 months, because I think may not have the capacity to pay. Otherwise, nobody would like to be behind bars for that much of money. And this maybe discretion, the sentence and the default part also is a discretion on the revisional court. We may examine. So that may be the period undergone, maybe if the complainant is not likely to get the fine, what he is going to achieve? If the lady is, I don't know the capacity, but there is a presumption that she is not having the capacity to pay.
If she posts that 3 months or so,
Uh,
that complainant may not
Complainant
get
is not
it.
going to receive anything. That is the situation. Considering that it is a lady, that is why.
Lordship.